All right, and I know we're expecting one commissioner should be here and another one's arriving late, but I'm going ahead and call this special study session, this joint session with the Planning Commission and the Town Council to order. I'll ask our clerks to take roll of our planning commissioners and council members, please.
Councilmember Rennie?
Here.
Councilmember Moore?
Here.
Councilmember Hudes?
Here.
Vice Mayor Badami?
Here.
Mayor Risto?
Here.
Commissioner Thomas? Commissioner Hanson? Commissioner Jenoff?
Here.
Commissioner Burnett?
Here.
Vice Chair Rasby? And Chair Burnett.
And it looks like we have Commissioner Hanson arriving. I'll give her a moment to get seated. Welcome. Okay, first of all, we're not going to roll our video of decorum and civility. I think everybody knows what's expected. I'm just going to remind people we'll be civil. We're going to remain on topic. And when we get to verbal communications, it will only be on the topic of the state laws that we'll be discussing tonight. So we will not, because there's only one item on the agenda, we only have verbal on that one topic. And then a reminder that each speaker gets 3 minutes, and if you exceed that, the microphone will be turned off and the camera will be turned off of you. So there's no point in continuing. Anyway, with that, I think we're here for a good study session. In terms of context, I just wanted to let people know in the spring, Los Gatos began to get a couple of SB 330 pre-applications. And that law, and staff will go more into detail, but that law has been in place since 2020, but it was new to us to get pre-applications under SB 330. And I certainly was hearing from people and understood that there was concern, what is this, what does it mean? And when I talked to our town manager, we decided that we should have a study session in the fall. Over the summer, people are gone. This is a good opportunity. The pre-applications have 6 months to become an application. So before we get to the point that we're going to start having hearings and see the implications of this state law, it was a good opportunity to do an education for our council, our commissioners, and our members of the public. So with that, I really do want to thank people for showing up. I can see a lot of interest on Zoom and in this room, and I appreciate that. And I also want to thank our staff and our planning commissioners for making the time for this meeting tonight. So it will be important for us to understand where we do and don't have discretion, and that's kind of the point of this meeting as we talk about the laws. So I will turn it over now to our town attorney, Gabrielle Whalen.
Good evening, Town Council and Planning Commissioners. As the Mayor mentioned, this is a study session which has been scheduled to discuss the housing laws that affect planning applications submitted to the town. We're very fortunate to have Barb Gatos joining us this evening. Barb is a statewide housing expert. Before law school, she served as a community development director, and now as a lawyer, she's a preeminent housing lawyer in the state. Barb will be describing the state laws. There have been about 17 state laws regarding housing, but we're going to discuss the laws that are the most relevant to Los Gatos. And so as a preview, those include the Senate Bill 330 preliminary applications, the Builder's Remedy, State Density Bonus Law, and the California Environmental Quality Act. This will not be a meeting at which to comment on individual planning applications, but we are holding this study session because the town has received several planning applications that reference the laws that I just listed. And Mr. Paulson, the town's community development director, is going to give just a list of the projects that have been submitted that cite those state laws.
Thank you very much. Good evening. Joel Paulson, Community Development Director. As was mentioned by the Mayor and the Town Attorney, there have been 4 SB 330 preliminary applications that have been deemed submitted. Those are a site on Alberta Way, the Los Gatos Lodge across the way from Alberta Way, the post office site where the current post office is, and a phase of the North 40, which is about 15 of the 20 remaining acres that still need to be developed. The Alberto project has actually submitted their formal application. They utilize the 330 preliminary application, and they're moving forward using state density bonus law, not builder's remedy. The two sites that have cited builder's remedy are the post office site and as well as the Los Gatos Lodge site. So the other North 40 component, the second phase, as some people have called it, they're just relying on state density bonus law. They have not invoked builder's remedy.
Thank you, Director Paulson. I'll now turn to Barbara Kautz for presentation. And just for my fellow council members and commissioners, we'll have Ms. Kautz go through the entire presentation, and then we'll have the opportunity to ask questions and expand. Thank you.
Thank you very much. I'm pleased to be here. I have a PowerPoint, which I think the city clerk's going to put up. I should say, I'll just give some introductory remarks. So I've been asked to describe some of the new state housing laws, and particularly to focus on preliminary applications, which people also call SB 330 applications, and the builder's remedy because of the applications that Los Gatos has received. But there's really been a flood of bills since 2017. In one article I saw, there were over 100. So there are many, many bills, many housing bills, and which I would say are overall quite poorly written, often contradictory, and very difficult to understand. So my presentation just covers a fraction of the new state laws involving housing, but if people have questions about other bills, I'd be happy to talk about them. So next slide. So just as an overview of the presentation, I'm going to very briefly talk about state housing policy. Then I'm going to describe what the builder's remedy is. Then I'll talk about the effect of preliminary applications and the interaction between preliminary applications and the builder's remedy. I'm going to quite briefly talk about other key laws, density bonuses, SB 35 streamlining, AB 2011, which allows residential development in commercial areas, and some other bills. And then I'm going to spend a few slides talking about generally how the state of housing litigation today. So next slide, and then the next slide. So I think the state housing policy in relation to local approval of housing projects can all be summed up in this slide. This is a quote from the Housing Accountability Act. And what the legislature said, they adopted this language in 2017, and they've been working hard at it since, is they want to curb the ability of local governments to deny, to reduce the density of, or to make housing development infeasible. And when they adopted this in 2017, they said this intent has not been fulfilled, meaning that they wanted to make it much harder for communities, cities, and counties to deny affordable housing, to deny any kind of housing development. So next slide. And so one of the ways they've done this is through what's called the Builder's Remedy and the Housing Accountability Act, which really affects all housing development projects. But the key provisions that apply to the Builder's Remedy applies to projects that are considered affordable. And a project is considered to be affordable if 20% of the total units in the project are affordable to lower income households. And there's the statute includes what the maximum rents, or if 100% of the units are affordable to moderate income households. But generally, when people invoke the Builder's Remedy, they come in with a project where 20% of the units, of the total units, are affordable to lower-income households. A project is considered to be a housing development project so long as 2/3 of the square footage is devoted to residential use. So it can be a project with a fairly large component of commercial use. Next slide. So this is what the builder's remedy provision is. So if a project is proposed where 20% of the units are affordable to lower income households, then for the city to deny the project, it must make one of these 5 findings, which I've substantially summarized here. One is that the town has actually built all the housing assigned in its RENA, which I think difficult to find any community that can make that finding. Secondly, that there's, quote, a specific adverse impact to public health and safety. Now, this is a much stricter standard than a typical environmental impact. The adverse impact has to be based on on objective standards that were in place when the application was found to be complete. So it has to be based on some kind of adopted standards. It can't, for instance, be based on saying it'll create an evacuation problem if there's no evacuation standard established. So it has to be something where there's a standard established, and that the impact cannot be, and that there's basically no way to mitigate the impact. So it's quite difficult to make this specific adverse impact finding, and I haven't actually yet run across a project where a community felt they could make this finding. It can be denied if it's necessary to comply with state or federal law, but not local law. It can be denied if it's proposed on agricultural land or the water or sewer is inadequate, but to deny it if it's zoned for agriculture, it has to be surrounded on 2 sides by land actually used for agriculture. And then the last means to deny a project with 20% affordable housing is that it's inconsistent with both the zoning ordinance and the land use designation in the general plan. But to make that finding, a community must have a housing element, must have adopted a housing element that's in substantial conformance with state law, and the project can't be proposed on a site that the housing element designates for lower or moderate income housing, and that meets the density that's in the housing element. So when developers believe that a city has an inadequate housing element, they've been applying for projects that don't conform with the local general plan and the zoning, and they argue that the project can't be denied because the city is unable to make any of these 5 findings. If this town, and then the legislature, even if this town believes it can make one of these 5 findings, the legislature has made it difficult to support it. If the town makes one of the findings, the findings have to be based on the preponderance of the evidence rather than just whether there's substantial evidence in the record, which is the usual standard, and the town bears the burden of proof in defending any litigation if it denies a housing project. If the town loses, it's liable for the applicant's attorney's fees. And so, anyway, if HCD finds a housing element inadequate, there's a rebuttable presumption that the housing element is adequate. But the courts have varied a lot in how much deference they give to HCD's view of adequacy, which I'll talk about a little bit more later. But in any case here, the way the Housing Accountability Act is set up, it's basically the burden of proof is on the city, and you have to have a preponderance of evidence in order to deny the project. Next slide. So why suddenly is there this burst of activity around the builder's remedy? This provision was enacted in a very similar form to today's form in 1982, but there's no published cases whatsoever. So why has it suddenly exploded? I saw a list, and between that list and what I knew personally, at least 30 cities have had builder's remedy applications, pretty much all in coastal regions. Well, one is that it's much more difficult to get a housing element approved by HCD in this cycle. The housing element laws were changed substantially between the 5th cycle and now we're in the 6th cycle. HCD's much more rigid. And so because the builder's remedy applies when the housing element is not substantially compliant with state law, there's many more cities exposed because it's so much harder to get the a housing element approved. Also, a UC Davis law professor, Chris Elmendorf, wrote an article which got extensively publicized, so developers started paying attention to it. I think there were something like 20 projects proposed in Santa Monica. That got a lot of publicity, and now you're not alone. That's all I can say. It's become much more utilized in this cycle than, actually, I'd never seen anybody file such an application before. So next slide. So now I want to talk about the effect of preliminary applications, which were referenced, and how they interact with the builder's remedy. Next slide. So a preliminary application is basically an abbreviated kind of mini planning application that must meet a list of about 19 very specific and limited requirements. But the advantage of filing a preliminary application is it freezes the development standards in place as of the date that all the required information was submitted. So in some ways it's like a development agreement, except that developer has to do much less. All the developer needs to do is file the preliminary application. These preliminary applications are filed pretty regularly throughout, even in cities that have adequate housing elements. As an attorney, I think if I represented a developer, I think it'd be malpractice not to advise the developer to file one, because it provides protection against any future changes in development standards, and in particular in changes in fees, with very limited exceptions. But for the preliminary application to be useful, a regular project application has to be filed within 180 days, and the applicant has to complete the application within 90 days after receiving an incomplete letter from the city. The developer can change the project by up to 20% of the square footage or the number of units and still rely on the initial preliminary application, and maybe more importantly, the developer can decide later to invoke density bonus, which can provide, which for a mixed income project can provide bonuses as high as 50%, and still rely on the initial preliminary application. The one possibly, as I've noted, can be submitted for any housing project. Getting a preliminary application could be just, it may have nothing to do with the builder's remedy. But the one big exception where cities still have some authority is that a city can apply a new ordinance that mitigates environmental impacts. And if some kind of environmental review is done, a city can apply the mitigation measures. Those are probably the big exception beyond what's already in your in your ordinances. Next slide. So the interaction between the preliminary application and the builder's remedy. So there's a big unresolved issue, which someday will be resolved in a court case, about whether the preliminary application freezes the adequacy of the housing element at the time that the application was submitted. So think about a scenario where somebody filed a builder's remedy application at a time when just arguably the town's housing element didn't conform with state law. But by the time the project was heard, the town had adopted an adequate housing element, and best case, HCD had agreed that the housing element was adequate. So does the developer then have a vested right, basically, to the inadequacy of the housing element? HCD has opined that the adequacy of the housing element is frozen and is frozen at the time that the preliminary application was submitted. But, I've heard good attorneys make arguments against that. And as I said, at some point, HCD's determinations aren't law. They're only its opinions. And at some point, there'll be a case that will resolve that. Next slide. Just some other key processing provisions that are not necessarily, that are not related to the preliminary application or the SB 330 application, but have been some have been in effect for many years, and some have been adopted in the last 5 years or so. So the formal application is subject to the Permit Streamlining Act. The town has to review it for completeness within 30 days, or it's, quote, deemed complete. But the new part is once it's complete, the staff has to notify the applicant within 30 days, 30 or 60 days, 30 days if the project has 150 units or less, if there are any inconsistencies at all with any of the town standards, whether it violates setback heights or any other standards. If the applicant is not informed the project is deemed consistent with all town standards, and I just got a call from a client where they initially responded within 30 days and the applicant resubmitted, and somehow the resubmittal was lost. And so they didn't, so that city didn't let the applicant know if it was complete or not within the 30 days, so it was deemed complete. And then because the resubmittal had been somewhat lost, and after another 60 days, it was for a big project, it was deemed consistent with all the city's ordinances, even though there were actually some major inconsistencies. So it puts a lot of pressure on planning staff. In some ways, I'm glad I'm not a community development director anymore, Joel. Next slide. Other key changes that the legislature has adopted since it's starting in 2017. One is that a project is assumed to be consistent with a policy if there's substantial evidence that would allow a reasonable person to assume consistency. So basically, those scales are weighted in terms of finding a project to be consistent with all the city's standards unless the argument is unreasonable. And another important change is that no rezoning is required if the general plan is inconsistent with the zoning. So an obvious inconsistency would be general plan shows residential, but the site's still zoned commercial. Okay, that's an obvious inconsistency. In that case, the developer could build the residential development without getting a rezoning. But once a project's shown as suitable for lower or moderate income housing in the housing element, probably those housing element densities apply even if the zoning hasn't been adopted. We've seen developers make quite creative arguments on this issue. It's another issue which, allows people to make a lot of arguments about what inconsistency means. Next slide. Regardless of all this, if the project does require some discretionary approval, CEQA still applies, the California Environmental Quality Act. So in terms of builder's remedy applications, many exemptions require that the project conform with the general plan and the zoning. And so if a project clearly does not conform with the general plan and the zoning, then it may well not be eligible for any of these exemptions. As I mentioned, mitigation measures can still be imposed. But the grounds for actual denial of a project under CEQA, looking at it with the Housing Accountability Act, are still unclear. For instance, if there are significant unavoidable impacts, the town is required to make a finding that the benefits of the project override the inconsistencies. Well, what if the town didn't feel they could make that finding? Would that allow the project to be denied? It's another area ripe for litigation. In Santa Monica, the city initially started processing all the builder's remedy applications, and I believe was requiring EIR for all of them. And given the time and the delays, the proponent of most of the builder's remedies projects in Santa Monica settled with the city and agreed to conform with the city's zoning in exchange for some expedited processing. So CEQA still provides some room for local discretion, but it's really about the only one. Next slide. And then the other important limit is that projects are limited to 5 public meetings organized by the town. Now, there's exceptions to the 5 meeting limit. One is meetings held before applications complete. So sometimes communities have a study session, before the application has been found to be complete. Those don't count. A project not consistent with objective standards, so does that apply to a builder's remedy project? Projects that require legislative approvals like rezonings and general plan amendments. Additional meetings required by CEQA aren't included in the limit, and meetings not conducted by the town. So a meeting organized by the developer, meeting organized by a neighborhood group, none of those count as part of the 5 public meeting limits. So, and then as I mentioned, I'm just going to talk briefly about other key laws. Next slide. The density bonus law is probably the most significant, and it's expanded by the legislature every year. Virtually every year, this bill is amended. We were once trying to do a legislative history 2 years ago and found there had been 37 amendments to the density bonus law, which made it difficult to figure out what were the key ones for our purposes. But anyway, so a project is eligible for a density bonus when it contains anywhere from 5% very low-income units or all the way up to 100% affordable project. And once a project is eligible for a density bonus, whether or not it actually requests a density bonus, it's entitled to receive, first of all, a density bonus, at least 20%. 100% affordable housing project is entitled to at least an 80% bonus or an unlimited density if it's within half a mile of a major transit stop or in what's called a low VMT area, vehicle miles traveled area. I'm not aware if any are located in Los Gatos. It can get anywhere from 1 to 4 what are called incentives or concessions, and those are basically changes in standards to reduce a project cost. For instance, something like not undergrounding the utility. But probably the most powerful provision is the ability to obtain an unlimited number of waivers of the city's development standards, so that a developer can ignore, both usual zoning standards like height and setbacks, as well as objective design standards. There had been a number of theories about what limits could be put on waivers, but there's a case out of San Diego maybe a year or two ago, Bankers Hill 150 versus City of San Diego, where the Court of Appeal decided, even though the issue had not even been briefed by either party, that density bonus waivers must be granted for a building for the project as designed, unless the city can make one of three findings: one, that the waiver would violate state or federal law, or you could make that specific adverse impact finding that I discussed earlier, which is almost impossible, or that it has an impact on a building listed in the California Register. So it's only under rare circumstances that a waiver can be denied. A developer is also entitled to reduced parking requirements. The Housing Accountability Act says that a density bonus project is considered to be consistent with the town's standards. Next. One question I've always wondered with density bonuses, given how generous density bonuses are, why bother with a builder's remedy? I think, so we've basically seen it in two cases. One is where somebody wants a development much higher than the density they could otherwise get, or that they don't want to meet minimum density standards. Developers often feel they can make more money with a lower density product. So. Anyway, inclusionary units can qualify a project for a density bonus. So the town requires anywhere from 10 to 20% lower or moderate income units in all projects with 5 or more units. And so all those projects are eligible for a density bonus. And for the parking reductions, concessions, and the unlimited waivers that they're entitled to. Next slide. So this is just this was a project in a city, had a 3-story height limit. And so the developer had, in this case, had a 35% density bonus because this is before the maximum was increased to 50. And you can see it's now a 5-story building, which the city, so the main waiver here was for height, but it's not uncommon. Next slide. Then the legislature adopted some streamlined review process, which people generally call SB 35, although the code section's been amended numerous times, and I just saw that there's been a major rewrite of it this year, SB 423, another Scott Wiener bill, and I will admit that I have not looked, I've not had the patience to look at it, but it again is changing the bill, the rules. But in any case, right now, today, it would apply to a multifamily residential project that would have at least 50% lower income. So that is likely to be actually a 100% affordable project. Again, 2/3 residential square footage on a site where the general plan allows residential use or mixed use. Two important limitations are, one, the site can't have had any housing occupied by tenants in the last 10 years. And if it has more than 10 units, the project needs to pay prevailing wages. So that has somewhat discouraged developers from using it, but nonetheless, it's being used more. The project has to be consistent with objective standards, but the developer is entitled to request density bonus waivers for anything that the project's not consistent with. Next slide. It has a very fast review time. There has to be a consistency review 60 to 90 days after submittal with a project 150 units or less having to be reviewed in 60 days. And then a decision has to be made 90 to 100 days, 180 days after submittal. There can be public hearings, but those frankly tend to be exercises in a lot of frustration for everybody because the town's discretion is so limited. And basically the town can only apply standard conditions. Another category of expedited review are, and the SB 35 projects are all exempt from CEQA. Another category are by right approvals. The town will need to zone any sites that are included in the new housing element that were used in the last housing element and designated for lower income housing to allow approval by right, and also any new sites that it needs to upzone. So by right is a little different. It doesn't have the strict time limits, but it does have no CEQA review, and only objective design review can be required, and a subdivision. If it requires, but to be eligible for by right approval, the project has to have 20% lower income again, and it can't require a subdivision. So this essentially would apply to a rental project that has 20% lower income. Next slide. AB 2011 allowed resident, and SB 6 allowed multifamily residential in certain commercial zones. AB 2011 is an incredibly complicated piece of legislation. I think it's like about 10 pages long in this document. So it has many, many requirements. But again, it has the very fast SB 35 timelines. Projects are exempt from CEQA. SB 6 also allows SB 35 to be used on sites zoned commercial, but only requires that the projects be half residential. So, next slide. I mean, the implications are that the town's required to accept and approve plans that conform with state law, even if they're inconsistent with the town's policies, and often, unless the project's discretionary, regardless of the town's or the community's concerns. So, next slide. Just a little about litigation. So, HCD and the Attorney General have been substantially budgeted to do enforcement on cities and counties. There's a housing accountability unit with at least 25 staff. To date, they've relied primarily on complaints. If a developer is not happy with the town's answer, he may go to HCD and look for another answer. But they also have, one of my acquaintances at HCD has just been named head of proactive enforcement. They've taken broader and broader authority. Typically, they initially, if they think a project's likely to be denied, they'll send a letter of technical advice to the town telling you what you should do. If you don't do what they ask for, they may send a notice of violation and then refer the project to the refer the town to the Attorney General. The Attorney General has at least a 12-person strike force, although I heard that he was asking for 4 more people. And sometimes it acts independently of HCD. One of my clients, somebody from HCD, from the AG's office, read an article in the paper, and immediately the city got a nasty letter from the AG. So the AG has can act on referrals from HCD, but can also act independently and does so. Next slide. What we've seen actually more here in terms of local agencies being sued are the active third-party litigants. So there's Californians for Home Ownership, which is funded by the realtors. There's YIMBY, which I recently read is funded by some of the Silicon Valley investors, and the California Housing Defense Fund, which was formerly called CARLA, California Rental, sorry. And so they've sued at least 10 Southern California cities and 12 Bay Area cities on their housing elements. And they often join in, or they're plaintiffs in litigation related to denials. So often when an agency denies a housing project, they're sued not only by the developer, but often by these third-party litigants, and then the AG may either seek to intervene or file his own lawsuit. So defending these lawsuits can be very expensive. And then next and last, what we've seen from the courts are that they're generally very pro-housing. I mentioned the case out of San Diego where they made an important ruling about density bonus law that hadn't even been briefed. One of the justices that signed that opinion is now the Chief Justice of the California Supreme Court. Anyway, so what we've seen is that the appellate courts in particular are generally very pro-housing. They tend to uphold housing approvals and overturn denials. Were the town to lose one of these cases, there can be significant attorney's fees exposure. Huntington Beach, which has sort of made itself a target for anti-housing litigation, was just assessed $3.5 million in attorney's fees regarding one of its case. There's high defense costs, even if the city wins. And what we've also seen developers now do is make takings claims in connection with these, and try to get damages in addition to their attorney's fees. It's possible for I've heard about concerns about the state taking over the city's housing. That would only happen if you were ordered by the court to adopt an adequate housing element, and 1 year later you had not done anything, and then delayed for another 6 months while you were getting fines up to $600,000 a month, and you still were refused to adopt an adequate housing element. At that point, a court might take over the housing element. But that, I would say, that has a very low risk of happening. And generally, our advice is to try not to deny projects or reduce their density, but try to apply conditions of approval that will make the project more acceptable. Those might still be challenged, but having an approval in hand is worth a lot to a developer rather than going to court. So I think with that, I am open to questions.
Thank you, Ms. Couts. And just so everybody knows, so we'll now do council and commission questions, and then we'll go to public comment after that. So I'll go with Council Member Rennie, and then Council Member Hudes, and then Vice Mayor.
Thank you. I have, I think, 3 possibly follow-ups on those. The first one is you used over and over the term low income. Let me go back to, you used it on the builder's remedy as a requirement, 20% low income. I wanted to clarify. So below market rate, you might be meaning below market rate, or you might be meaning there's a extremely low, a very low, a low, and a moderate level of below market rate. So when you said lower income, did you mean what's classified as the low income?
Yeah, lower income actually includes low income and anything below it.
Okay. Well, that makes sense, clearly. So my real question then is about the builder's remedy, which, as you said, is a much older law and not nearly as tightly written. The SB 330 pre-applications have a whole process. The first thing we get to do as the town is decide whether it's a valid application or not, and then continue from there. The builder's remedy, you didn't talk about that at all. What it looks to me like we're getting are these applications where they've been pretty careful about the SP 330, and then they said, oh, we also want to claim builder's remedy, but this 20% lower income is a fairly high bar. I only can think of one project, the North 40 Phase 1, where somebody actually met this 20% lower. Usually our projects are just 20% below market, so usually at the moderate level. And I'm gathering it's because it's harder to get it to pencil out. So this feels like a higher bar on the builder's remedy. But so we're getting these applications, and they aren't even stating that they're planning to give 20% lower income. They're just putting some very vague details that work for the SB 330, but nothing that seemed to show whether it's actually a valid builder's remedy application or not. So can you talk a little bit about the builder's remedy and that process?
Yeah, they don't have to say anything in their preliminary application about, whether the details about qualifying for the builder's remedy, right? I mean, they can write you a letter along with the preliminary application and say, this is a builder's remedy project, but it only is a builder's remedy project legally, eventually, if when they come in with an actual application, it's 20% lower income. Also, the state law also mandates quite low rents for these units. The rents are set at 30% of 60% of median income, which results in pretty low rents. So they have to meet all they have to qualify as what the legislation defines as a project for a project for lower income people in order to claim the builder's remedy. If they don't claim the builder's remedy, they're not eligible for the builder's remedy because they don't have enough affordable housing or the rents are too high or whatever, then they're subject to the Normal Housing Accountability Act requirement, which is that you can't deny or reduce the density unless it violates an objective standard. But that's a completely different. But it does freeze when they come in with the preliminary application. It does freeze your ordinances as they were.
And with the builder's remedy, freezes it to whatever housing element.
Yes, was
status.
in effect. Yeah, was in effect at the time.
So my last question, on the density bonus, you talked about unlimited waivers, and I thought there was a difference between waiver and concessions. But my real question was, and you gave the example of height. If we had a standard of, let's say, 35 feet is max height, and somebody came and they wanted a 50-foot building, that sounds like maybe a reasonable waiver. But what if they came with a 35 height limit, but they wanted a 100-foot building? Is there some point that the waiver is so ridiculous that it's not really valid?
Not the way the court discussed it. Yeah, I mean, I had a more inflammatory slide there. It's a picture you may have seen in the Chronicle of this tall, thin building in the middle of the Sunset. And I thought it was a joke, or somebody just making a point, but apparently the developer has sued the city to try to get that height.
Thank you, Mayor.
Okay, thank you. Councilmember Hudes.
Thank you, Mayor. I had two process questions. One is, will there be public comment, and will their questions be answered during this format? And then I have another process question.
Okay, thank you. Yeah, I apologize if I didn't go through the entire process. So at this point, we'll have all council members and commissioners ask questions of Ms. Kautz and the staff. Then I'll open it to public comment. Members of the public can speak up to 3 minutes, and if you haven't submitted a card, get one to the clerk, and you can do it during the process. And then I'll call a break, because I think it'll be late enough at that point. We will then have staff, after they've heard the public comment, if some issues rise up, that they give them the opportunity to address those issues. And then we'll go back to the council and the planning commissioners if there's follow-on questions that were raised by what members of the public stated. Thank you. Okay, Councilmember Hudes.
Yeah, the other question was about the participation in the meeting. And so my question, I think for the town manager is why is the town's housing consultant not at this meeting? I would be interested in their opinion about whether the January, the March, or the in-process housing element is in substantial compliance. And I think they're probably in a better position to offer an opinion on that than probably anyone.
Thank you for the question. Thank you. So thank you for the question. As you know, the town has been working diligently on its housing element to respond to all of the comments that have come from HCD. We are on track to bring to the Housing Element Advisory Board on September 28th an updated housing element draft that addresses those comments. The consultant is focused on preparing that draft, and so for that reason, they are not here. In addition, this study session is really focused on the housing laws, and because the town is making significant progress, we felt that it was the best use of our limited resources to really focus on the legal questions this evening and allow the Housing Element Advisory Board to continue its work to get us ready for certification.
Thank you. I have to say I am disappointed not to be able to understand the substantial compliance status of our housing element in the context of all of this discussion. It seems that substantial compliance is a key concept here. Thank you.
Thank you. Vice Mayor Badami and then Councilmember Moore.
Thank you. Ms. Privetti, thank you. I understand the focus tonight is to be on legal issues, but really this discussion tonight, it's wrapped around our housing element that's yet to be certified. And our audience tonight is composed of the largest number of residents in attendance that I have seen since the North 40. So there is a huge, significant amount of interest and concern with these laws and how we're handling getting our housing element certified and how we're interpreting the different laws. So I'm going to go right to my question, which is, how do residents know that the housing element adopted by the town council actually is substantially compliant with state law when HCD has stated in 3 different comment letters that revisions are necessary to comply with state housing law, and builder's remedy development applications have been filed citing noncompliance? So what level of evidentiary support is required by the court to find the element complies with state law? And is there a presumption of validity without HCD certification?
So the burden would be on the town to demonstrate by a preponderance of the evidence that its housing element was adopted in substantial compliance with state law.
It would depend. That's correct if it occurs in the context of the denial of a builder's remedy project. On the other hand, if one of these groups just sues the town, then the burden of proof is on them to demonstrate that the housing element does not comply with state law. But the standard that the courts have determined for the adequacy of a housing element, the case Fonseca v. City of Gilroy is probably the lead case on that, is that it contains all the elements required by the statute and that there is substantial evidence to support the conclusions in the housing element. That's if the housing element is approved by HCD, there's a rebuttable presumption that it's adequate, although the court just found HCD to be wrong in a recent case, Martinez v. City of Clovis. On the other hand, Fonseca says that there's no presumption of inadequacy if HCD did not find the housing element to be adequate. So there's not a presumption either way if right now, if HCD found the housing element to be inadequate. In terms of the kind of deference given to HCD's views, it's varied a lot. The Martinez case, despite finding HCD wrong, said that they gave great deference to HCD, although they actually, in the case, gave them none. There's another case, Rezninsky v. County of Marin, about interpreting the Housing Accountability Act, where the court gave no deference whatsoever to HCD. So I think a lot depends on whether the courts are convinced by HCD's reasoning.
Okay, so that being said, I'm very concerned that the town is being set up for a significant amount of legal fees, that we don't have the resources. But I'm going to go to my next question, and please define substantial evidence as you use in your presentation.
Oh my gosh. I'm not a good attorney right now because I should be able to have basically it's credible evidence. It's not a very high standard, to be honest. You know, it's something that's substantial, that that basically I would say credible evidence supported by facts, reasonable assumptions, that kind of thing. I mean, so you see it discussed mostly in CEQA cases. And so a court might find that, somebody might give testimony, and a court might find something that's not substantial evidence. For instance, if I were to comment on whether or not there's a landslide on a property, right? I don't have any kind of expertise about whether there's a landslide on the property. That probably would not be considered substantial evidence. On the other hand, somebody with some geologic experience, that would be considered substantial evidence. On the other hand, the courts consider lay testimony about traffic problems to be substantial evidence. If you say, every day I see the cars jammed at that stop sign when I drive through, the courts might consider that to be substantial evidence. So it depends I would say it's some kind of evidence that's credible.
Thank you, Ms. Kotz. I have more questions, but I'm going to wait and allow others to ask theirs.
Thank you. I'm going to jump in for a second before I call on Councilmember Moore, because one of the things that I want to frame this with is we do have the prospect of the builder's remedy because our housing element has not yet been certified, but there's a litany of other state laws that even if our housing element had been certified last month, we would still be having this study session, because what I'm hearing is that without a certified housing element, the only law that you brought up is the builder's remedy that would apply. So are there any other laws, state density bonus, SB 35, the streamlining, SB 330, that would not be able to be applied to us once we have a certified housing element?
Right now, it's just the builder's remedy.
Okay, so as we're discussing this, all of these limitations on our process and some lack of discretion that we'll have apply regardless of the housing element status.
Right. Preliminary applications, all the time limits I went through, SB 35, density bonus, those all apply to all cities regardless of whether or not they have an adequate housing element.
Okay, thank you. I just want to frame this because I want people to understand that this doesn't go away once the housing element is certified. This is the landscape that we're in, and we need to understand it.
That's correct.
With that, I'll go to Councilmember Moore.
Thank you, Mayor. And I'll just clarify, this council voted to move forward our housing element, right? We voted to push that housing element forward, and so I think it's a little. I don't think we can blame staff for the position that we're in, that we have a housing element that has been kicked back. Almost all other cities have had their housing elements kicked back, and so I think this is as the mayor stated, this is the position that we're in. So a couple quick questions that I heard from the community before this meeting. Can you define state density bonus for the community? Just define what it means, what the bonus is.
Oh, well, basically it allows a developer to have many more units than zoning would otherwise allow. So if there's a 50% density bonus, let's say a site would normally be allowed 100 units, whatever the zoning is. So with a 50% density bonus, project could get 150 units.
Thank you. And then sort of specific question. Do you know if in an HOA, if CC&Rs are in place, does the builder's remedy or any of these state laws, do they care about CC&Rs?
Let's see, the accessory dwelling unit law, there was another law amended to say that CC&Rs could not present, I think it's unreasonable obstacles to ADUs. There's another law that allows restrictive covenants to be removed for an affordable housing project. So in some cases, it varies. Yeah.
And one more, it varies is the sense I'm getting from a lot of this. And so one other question on when you talked about the Santa Monica example, you know, I think a lot of these applications, a lot of folks that I've heard from have been thinking that you submit this builder's remedy application, right? And if they check all the boxes, then that's it. And Santa Monica took a little bit of a different approach in actually negotiating with the developer, and the developer took some, the community applied some conditions of approval, and the developer took them. What latitude in general does a community like Los Gatos have in negotiating with the developer once a builder's remedy application has been applied? Because I think there's a lot of concern, but I think there's a lot of I think the developers sometimes seem to be using builder's remedy because they feel like that is the way to get this through. And I think, if the town could talk with the developer, you could probably get to a better middle ground.
Well, there's always room for negotiation. I think the town's desire would be that the developer would conform with the city's zoning. And conforming with the city's zoning allows the developer to use density bonuses. I mean, I think that was really the outcome in Santa Monica. Rather than quite as high density as the developer wanted, they got density bonus densities. I think from what I read in the paper, the city also agreed to allow them to cluster their inclusionary units, I think, on a site, some other things like that. So, I mean,
yeah, no, that's helpful. Thank you.
Yeah.
Okay, thank you. Then I'll go with Commissioner Burnett, and then Commissioner Hanson, and
Thank
then
you.
Commissioner Janoff.
Thank you very much, Ms. Katz, for coming tonight. I mean, you're answering a lot of great questions. I have a question. It seems to me that how can all these laws be passed? And I know we have CEQA, but a lot of these laws give a pass to CEQA. We have a town like Los Gatos that has limited resources, water. We have high fire danger zones. I mean, I live in a severe high fire area. We have transportation is very limited in Los Gatos. We don't have any transit facilities. So, I mean, when these laws were passed, didn't anyone bring up some protection for cities like Los Gatos and smaller towns that have big issues supporting large projects that we look like we're going to be having? I mean, it's a real concern. I just don't understand why someone hasn't pointed that out. Thank you.
I think you should talk. I mean, I do think that while the state is supporting housing, they have not done very much on infrastructure. But really, it's really a conversation with your legislators.
Is that it? Okay.
Yes, thank you.
Then I'll go to Commissioner Hanson.
Thank you, and your presentation was very helpful. I have two questions. The first one is, you mentioned on the standard for affordability, you mentioned rentals several times. And the thing that we face here in Los Gatos all the time is that nobody wants to build rental units because they would rather sell them. And even more affordable units are still pretty expensive.
Right.
So is there a standard in affordability that factors in rentals?
Yeah, there is a standard for rental housing.
Well, I mean,
Yeah.
where generally rentals, so we have very affordable
Yeah, I mean,
units
I'm
in the
sorry,
North 40. Yeah.
I didn't answer your question. There is a standard for sale housing.
Right, and that is there a different one for rental housing?
I was just going to see if there was a different, it also has to be lower income. And I don't know if the number I cited you for rent is what the mortgage would have to be as well. I was just going to look that up.
Okay.
Yeah.
That would be helpful to understand
Yeah.
as we go forward with this process.
Pardon?
Because that seems to be a huge factor. And,
Come back to it.
and the very low affordable units that we have
to
in the
look
North
at
40 are rentals, whereas everything else was for sale, and they're all pretty expensive. And so those were income restricted. But I think that's important to understand. My other question is about the density bonus law. What is the current version of the density bonus law for this year? Is it AB?
Sorry, I don't remember. There's about 3 density bonus bills. One would increase actually the maximum bonus to 90% for a project with 25% very low income housing. But I'm sorry, I don't have the numbers of the bills at the.
Well, so let me state the reason that I asked. As I was listening to this, and Director Paulson mentioned we have the 4 SB 330 applications. 2 of them are using the density bonus law. The other 2 are using the builder's remedy. If the standard for density bonus law is 5%, it's not clear to me why anyone would do the builder's remedy because they would have less units. I imagine there's probably a sliding scale, at least the last version I've ever seen of it. There's a sliding scale depending on how much affordability, but I don't know
Yes.
the current law.
I mean, it's easy. So for very low income units, if you have 5% very low income units, you get a 20% bonus. If you have 15% very low income units right now, you get a 50% bonus. And then there's a sliding scale that goes up.
Okay, so, and then I'm going to guess at 20%, it's still going to be better for them to do the density bonus law, but they would have to evaluate based on what they'd like to do with the project.
Yeah. So as I mentioned, one reason for using the builder's remedy is to reduce density, is to get density below the minimums that are required in the housing element. So that might be one reason for using the builder's remedy. But there may be some developer who wants more than a 50% bonus, who wants more than 50% increase in the number of units.
But you had said in your presentation it was up to 80% and then or unlimited for the
80% and unlimited apply to a 100% affordable project.
Okay, that's kind of what I was looking for.
And
okay.
in terms of your question about the standard for sale housing, it's the same. The monthly payment is the maximum monthly payment is the same for rental housing or for sale housing. Now, obviously, figuring out what purchase price coincides with that maximum monthly payment is more complicated, but it's the same. It's a relatively low number.
Okay, thank you.
Okay, I'll go to Commissioner Janoff.
Thank you. There have been some nuances mentioned regarding lawsuits and the potential for lawsuits and what's at risk for the town of Los Gatos. It's my understanding that the risk of lawsuit is what would happen should the town deny a project. But is there just an open-ended risk for lawsuit at any point? I mean, it doesn't make sense to me that there wouldn't be some damage that's been incurred that would trigger the lawsuit. So if you could clarify yes. what the real risk of lawsuit to town of Los Gatos would look like.
So with any housing development project, there's a risk of a lawsuit if the project is either denied or reduced in density or or the town tries to apply a standard that wasn't in place when the preliminary application was filed. That's what is listed as a cause of action under the Housing Accountability Act. If you deny a project that has 20%, the 20% lower income we talked about, there's also a cause of action if you apply a condition that makes the project infeasible. And then the other risk of lawsuit would be for having an inadequate housing element.
And that risk is a risk from the state?
It could be from the state. As I said, it's what I've seen more commonly is from these third-party groups like EMB Law, the Housing Defense Fund, and the Californians for Home Ownership.
So two follow-up questions. One regarding Councilmember Moore's question about the town's discretion at being able to negotiate with developers. The kind of conditions that you're talking about being subject to a lawsuit would be not the things that you're negotiating back and forth in good faith, but it's something that would happen after, like a denial with conditions or something like that. But we can still negotiate with a developer and not be at risk of a lawsuit.
Yes, you can certainly always talk to a developer and try to get a better project.
Just want to be clear about that. The second thing with regarding if we don't have a housing element in substantial compliance or one that's been approved by HCD, we're in the process of generating that, and the town is making extraordinary efforts and good faith efforts at moving that process along. There's been comments back, but fewer comments, and I think with the help of the consultant, we're making very good headway. Given that the town is in a good faith process of creating a compliant housing element, how at risk would you say? I know this is speculation, but does it make any difference?
I mean, it's hard to know. We're defending 3 of the cities that were sued, and it's a little hard how they picked them out. It's a little hard to know how they picked them out. I mean, one of the cities that's being sued is Richmond. Now, Richmond, really, that's a poor community, relatively poor in the Bay Area that would love to have more housing. So, anyway, so I don't know how they pick.
All right, thank you.
Yeah.
All right, I'll go back to Councilmember Rennie and then Vice Mayor.
So, Mayor, as we're moving away from questions, I wanted to make sure council members and maybe even planning commissioners are thinking about council meetings, study sessions are public records. Public records end up in lawsuits. If we were in a builder's remedy lawsuit, for example, things said in this meeting could end up there. I lived through the North 40 Phase 1 where we denied the project. We got sued, it went to court, we were forced to approve the project. In that, I recall the plaintiff writing things like, well, council member X said this in support of it. So if, for example, a council member here is arguing, and we end up in a builder's remedy lawsuit, is council member here arguing that the builder's remedy or we're not in substantial compliance, and then they vote against a project that is a builder's remedy project, that's going to hurt us, for example. So I just want the council members to think carefully about how they word their questions.
Thank you. Good reminder. I'll go to the Vice Mayor and then Councilmember Hughes.
Thank you. So the process of submitting a development application can be iterative. So once the town issues a deemed submitted letter for SB 330 applications, preliminary ones, is the preliminary application deemed complete? And if it's deemed complete, should the preliminary application be considered a pending project and available as credit toward our RENA in the site inventory? And one last follow-up question is that the residents are aware of 4 SB 330 applications, and I sense outrage, especially with the post office, and I'm going to suspect that's why a lot of the residents are here. Can we anticipate more SB 330 applications, and are there more in the pipeline? So I've got a couple questions in there.
So I will address those questions. With regard to the question of whether or not to treat SB 330 pre-applications as pending projects, town staff discussed this in our meeting with HCD staff on September 5th, and HCD staff stated that it'll be a pending project once the actual planning application has been submitted. And then your second question had to do with the post office and whether or not the town could anticipate receiving additional SB 330 applications. My guess is that this town probably will continue to receive SB 330 preliminary applications, and I suspect that will continue even after the town's housing element has been certified.
Thank you.
Okay, Councilmember Hudes, and then I'll go to Chair Barnett.
So I had a quick follow-up to that, and then I had a substantial question about objective standards. With regard to the pre-applications and applications, how long does the town have to evaluate whether a pre-application is considered submitted?
I believe it's 30 days, and I'll look to Mr. Paulson to confirm that.
Thank you. But yes, I believe it's the same as normal Permit Streamlining Act, which is 30 days. They haven't taken that long. The times when we've had some submitted that were lacking information, it took the applicants a little while to get that information back, but that hasn't been a concern to date.
Okay, thank you. As I understand, there are some more in the pipeline, and it would be good for the public to understand when those might be deemed submitted. The question I wanted to get into was about objective standards, and how do objective standards come into play? And Ms. Couts, have you looked at the town's objective standards?
No, I've not looked at any of the town's objective standards. The objective standards come into play because the city, in reviewing an SB 35 project or any kind of housing development project, the city's decisions have to be made based completely on conformance with objective standards. So
as a follow-up, the town adopted some objective standards last November, but those omitted some areas that we've seen in some other communities. And so I wanted to get your reaction to some of these and whether they could be considered objective standards if the town put the effort into them. So one of them would be hillside views from a prescribed location, which either exists or it doesn't exist. Santa Cruz has objective standards on high-quality building design that incorporates features of the building themselves. Also things like dark sky lighting and ways to keep more existing trees in a neighborhood. Morgan Hill has objective standards regarding projects that are adopted within the wildland urban interface fire area that requires a protection plan. Pismo Beach has view standards to protect existing views, and so does Grover Beach. And Palo Alto discussed, but I don't know whether they adopted options of architectural styles. And San Bruno also addressed architectural style regarding the compatibility of an accessory dwelling unit with the main structure. So any reaction to those possible areas of objective standards that I do not believe exist in the town's existing objective standards?
I mean, I think with the possible exception of views, which I've heard are very difficult to define objectively, these can all be defined in, high quality building design can be defined, but you have to define what you mean by that, right? For instance, a list of materials, the windows have to be a certain style, I mean, they all need to be translated, if you like, into a specific almost specification for a building design. Anyway, for ADU design, that's possible, except that HCD's view is that for detached ADUs up to 800 square feet, that the city cannot apply any design standards at all. So, but it is certainly possible to come up with, for instance, some of our clients say that the materials on the ADU must be the same as the materials used on the home. I mean, something like that. That's simple and clear, but
so
yes, you can define all these if you can turn them into specifications.
So one quick follow-up to that. If the town were to continue to work on its objective standards, I assume those would not apply to these pre-applications, but they could apply as of the time when those standards were adopted. Is that correct?
That's correct. The other risk the city runs into is that a developer can choose to ask for a waiver from them, but they can apply, yes.
Okay, thank you. I'll go to Chair Barnett.
I join in. Thank you for your excellent presentation and being here tonight. Can you speak to the January 31st zoning requirement?
Yes, the statute says that if HCD had not approved the city's housing element by May 31st, that the city must complete all the rezoning for lower income housing basically by January 31st of 2024. Or the housing element will be inadequate at that point. Yeah.
Oh, so the remedy would be what?
Somebody suing you again, somebody again alleging that your housing element's out of compliance and filing a new builder's remedy application. Yeah.
And then, I mean, one more thing is the law provides that HCD won't be able to certify the town's housing element until the rezoning has been completed.
Correct.
Right. And then maybe an easier question. Can you give examples of the conditions which you feel the town might be able to impose as part of developments without running afoul of the state statutes?
There's a case, Carla, who's Carla v. City of San Mateo, where the city San Mateo had turned down a project saying that it didn't conform with an objective standard. The court did not agree that the standard was objective, but it did say that the city could have applied a condition of approval to do it. It just couldn't have. The issue had to do with whether the top story, it was a 4-story building next to a single story home, and the court said yes, but you could have required that the 3rd and 4th stories be stepped back, to reduce the impact on the home, even though those even though that wasn't an objective standard. You could apply objective standards to reduce impacts so long as they don't reduce the density. So that's what the court said, but I think it's a very limited, option.
Thank you for that.
Okay, and then as a follow-on to that, since it was raised with and then I'll go to Commissioner Thomas. With the deadline in January, I don't know if Director Paulson can update us to, how we're meeting that deadline.
Thank you, Mayor. So the timeline we're currently on, as was referenced earlier by the town manager, is we're hoping to resubmit a complete revision in early October. which would mean that we potentially could get a letter back from HCD in December saying, yep, you now have a housing element that can be certified. If our rezoning has not been done and in effect by that time, they won't be able to make that determination. So that would be a requirement. I've seen it in other letters where you need to complete this before we can certify your housing element.
So where are we on the zoning?
Thank you. So the zoning is going to Planning Commission tomorrow night, one portion of it, and then I believe, we'll look for someone to throw a pencil in the back of my head, October 3rd, it will be coming to council for the creation of the general overlay zone for both the general plan and the zoning code, and then the elements for these specific sites that are in the sites inventory of the current housing element.
Okay, thank you. I don't know if Ms. Armour has anything to add, but I mean, I felt like as I'm watching the meetings and agendizing things, we're well on track to more than beat the January deadline. I'll go to Commissioner Janoff and then Commissioner Thomas.
Just as a follow-up question, it's my understanding that staff is well on its way to amending the zoning. Are you saying that the list that we have before the Planning Commission tomorrow night that will presumably go to Town Council in October, is that the body that would be complete, or are there still loose ends with respect to making the zoning changes that would be required?
Thank you for the question. So that would be the entirety of the zoning at this current point.
So
further down the line, after the housing element is certified, there may be other actions we'll need to take, but that is on the path we're on currently.
So that would be well in advance of the January 31st deadline?
Correct.
Okay, thank you. Now I'll go to Commissioner Thomas.
Thank you. My question is with regards to a SB 330 preliminary application, and then I believe that I just want to confirm that after that has been filed and acknowledged by the town, the application, that the real application, formal application, has to be filed within 180 days. So what happens if the developer or applicant fails to do that?
The statute says that then the preliminary application is null and void.
Okay, so they would have to file another preliminary
Yes.
application.
Yes.
Okay. Thank you.
Thank you. Okay, I'll go to the Vice Mayor.
Thank you. So I also have a follow-up question for Mr. Paulson. Sorry. You had referenced a meeting on September 5th, which I would, speculate that involved our housing consultant and staff and perhaps the HCD. And if so, was there any feedback on the adequacy of our site inventory?
Thank you for the question. That actually wasn't me. That was the town attorney that mentioned the meeting on September 5th. But we did have a meeting. They are still, they're very close. We're hoping to have information from our consultant soon to determine that, yes, this site's inventory, based on the parameters that they've come up with to show adequacy to the state, we believe are going to be in line with where we're at. So we should be comfortable with the site's inventory at this point.
Mr. Paulson, thank you, and my apologies for mixing up the conversation.
Okay, do we have any other questions now? There will also be an opportunity for council members and commissioners to ask questions after public comment. So I'm not seeing any hands on Zoom. I have 24 cards right now, so I will give everybody their 3 minutes. And when we're done with public comment, we will take maybe a 10-minute break and then come back for explanation and more questions and comments. So my first speaker is Tina Johnson. So when I call your name, just come on up to the microphone, introduce yourself, and there will be a timer with 3 minutes. And just so you're ready, James Bowen will be following Tina.
Okay, I'm a bit of a disappointment for you because I'm representing Bellwood, not the post office. Our neighborhood has been impacted dramatically all of a sudden within weeks. We were told that the school district sold our beloved school, or half of it anyway, to a developer, and the deal was done. And we live in Bellwood. And if you don't know where Bellwood is, it's over by Harwood and Lee. And that's where we've also had a few terrible traffic accidents in the last 6 months. There is only one traffic light that takes the whole neighborhood across Blossom Hill Road, which is where all the schools are, which is Nodden, Union, and Lee. The only way you can get across is through that traffic light. All the other streets are uncontrolled lights, and that's why we have so many problems with accidents. We have this builder going to come into our neighborhood and build these houses, and no one has addressed any of the problems in our neighborhood for traffic. We've had some serious accidents on blind corners in our neighborhood. I live across from 2 houses that were hit by cars as they were speeding around the neighborhood. We have blind corners. We don't have any sidewalks, or very few anyway. Our neighborhood is an extremely active neighborhood. We're walking all the time. If you come out there after 8 o'clock, it's standing room only with dogs, kids, and adults. And most of them are going back and forth from schools. Nobody has addressed any of the traffic problems to do within the neighborhood also. If people come out of the new development, they're going to go left on Gatos because they're not going to want to deal with the Stratford School District trying to turn left with no light on Gatos. So they're going to turn up towards the hills, go down West Hill. West Hill does not even have one stop sign from Gatos all the way to Blossom Hill Road. It is going to be a freeway. There are going to be accidents. There are going to be people killed. There are going to be children that are going to be hurt. This has to stop. We have to think about the neighborhood that we're building in. We don't have easy access off some of these other development sites where you can get onto a major street right away. You have to get through a whole neighborhood that's already having problems getting across Blossom Hill Road without any more developments. And then the school district put in Stratford, which doubled the amount of kids. Now, we know that's only during the school hours, but still, people are going to be trying to get through the neighborhood. So what are we going to do? Have accidents, and then there's going to be lawsuits. So that's my 9 seconds left.
Thank you. I'm going to remind people, we are absolutely not going to applaud or boo or speak. If you want to stand in support of someone speaking, that's fine. The other thing I would just like to clarify is we are not here to discuss any individual projects. None of these projects are before us yet, and there will be hearings when they come. So you are allowed to speak for up to 3 minutes, but the topic tonight is state law, and that's the only thing that we're here to discuss in the study session. Anyway, I'll go ahead and introduce yourself, and you can have your 3 minutes.
Yes, my name is Jim Bowen. I also live in Bellwood. We appreciate the fact that we were able to have this meeting tonight because a lot of us were informed of all of these new terms that none of us had ever heard of before. So it's great that you gave us an opportunity to come in and get a further explanation of actually what we're facing. It seems like Los Gatos is almost in the same boat we are. You don't have a lot of choices. So perhaps my question is to the building department. Will we have transparency as one of these? Actually, we know that the builder has purchased the property, but he has not submitted his plan for the property. He's informed the neighborhood of what the plan is going to be, but I don't think it's come to Los Gatos as of yet. How will we be able to be transparent with the building department as far as the community is concerned of what he's doing? We found out about this happening 2 days before the board actually voted on it and passed it and sold it to him. They didn't even inform the neighborhood. We found out through an email from our board itself. So it was kind of disappointing that they kind of sprung this on the entire community. That's why we're all here. Everybody here is from Bellwood. My other question is, so what transparency will we be able to have as a community with the building department as far as what the developer is doing and what they are conceding to him? The other thing is, as my wife indicated, the traffic situation. Will there be an environmental impact and a traffic study? And does Los Gatos prepare that as far as part of the conditions? Because those were evidently one of the main exception possibilities. We understand that we don't want to necessarily deny what he's going to do there, perhaps modify what he's going to do there, because it's kind of like knowing the enemy that you have as opposed to the one that may be around the bend. If he loses it and backs out, then there could be someone worse that brings in something worse for our neighborhood. So the transparency is one. If we're going to have any kind of a study, do we as Bellwood have to pay for a study to get if it is not complete enough from the city? Or what is that? So those are a couple of questions we'd like to address at some point. Thank you.
Thank you. And I see our staff diligently taking notes. And so our practice is not to answer questions with each speaker, but at the end, when everyone has spoken, we will then go through the list and address those issues. So thank you for raising them. My next speaker, hold on, if I can shuffle, April Mayton. And Jeff Suzuki will be up after April.
I think it's the same thing. I'm worried about safety. 2 people have died trying to get out of our neighborhood, and our neighborhood is very small. The roads are very small. There are no sidewalks. There are blind curves. I am just really worried about safety. I don't want anybody killed. And so far, we have asked for already to the town for speed bumps on our street because people go up the street 50 miles an hour, and it's not that long a block, but they're zooming to get to Harwood. And we asked for speed bumps, haven't gotten our speed humps, have not gotten them. Everybody's saying that we don't need them, but this is going to be a matter of life and death. Everybody walks in the street. There is no other place to walk. There are no sidewalks. There is a blind curve. There have been accidents. There have been deaths now. And the town of Los Gatos has not done anything and that's why a lot of us are here. It's safety. It is life and death. A 19-year-old died right on the corner of Gatos and Blossom Hill. Another one, a slightly older person close by. We want some assurances from the town of Los Gatos that safety will be a priority, because right now we're feeling like the poor stepchildren of this town, which happens a lot. You know, you guys only come out during election years. We understand that. Thankfully, we have a friend now. But anyway, we want to know about safety. That's our big concern. And I'm giving a minute and 22 seconds.
Thank you. Jeff? Oh, I'm sorry. We have a follow-up question from Councilmember Moore.
Yeah, not for the speaker, just real quick of staff, because I think a lot of these questions are going to be about traffic. Would you mind quickly talking about what our process is for a traffic impact analysis in a standard application?
Joel Paulson, Community Development Director. Yeah, the mic is a little bit, takes a couple seconds to pop on. So ultimately, when we get an application in, then Parks and Public Works staff will look at the proposed project. I believe this portion is predominantly field, so there's not a previous use. And then ultimately, they'll determine which type of traffic analysis, along with environmental analysis, which would also be determined when we get the application in.
Thank you.
Okay, thank you. Jeff Suzuki.
Good evening. I will not be speaking as a complete Streets and Transportation Commissioner tonight, but as a member of the public. I am the president of the Los Gatos Anti-Racism Coalition. The reason why I'm here today is a bit unrelated to the other public comments, but it's because someone forwarded me an email from Councilmember Gatos. The email effectively said that our housing policies have been hijacked by staff and a series of 3-2 majority decisions in support of denser housing. According to this email, for our housing element to be accepted by the HCD after being rejected 3 times, we must see the light of reason and moderate our proposals. But the truth is that the HCD hasn't said anything about how we need to lower the number of units for planned development. If anything, our housing element has been rejected, like many other cities, for not being progressive enough. To paraphrase the reports, as a high-resource community, we do not explicitly dedicate enough resources to make our community truly inclusive. I'm especially critical of the idea that efforts to support more development above the state mandate are somehow unreasonable. I'll tell you what's unreasonable. We live in one of the wealthiest parts of the wealthiest regions on Earth. We have homelessness that will certainly become worse as housing costs spiral out of control. And our current affordable housing program is a lottery where a rounding error percentage of applicants win a golden ticket to simply exist here. A study by the Othering and Belonging Institute ranked Los Gatos the 10th most segregated community out of 1,572 neighborhoods in the San Francisco Bay Area. We don't even need a study to tell us this. Literally look across the street at Los Gatos High School and tell me what you see. When I tried to search up its ethnic demographics, the percentage of black students often doesn't show up. Effectively a rounding error, because Los Gatos was built to exclude economically disenfranchised communities. And perhaps from these conversations tonight and in the future, we might choose to continue this exclusion, and that's unreasonable. In the past, we've demonized perfectly reasonable developments like the Habitat for Humanity project on Ditto's Lane, which proposed 14 affordable units. Then we as a community feared that such a project was going to bring in outsiders who would, quote, walk bulldogs and wear wife beaters. So we beat that development into the dirt until we retreated to another developer who proposed 4 units instead. Because of that, 10 working class families can't live here. By scaling back our efforts in the housing element, we are not only codifying these restrictions on the scale of individual projects, but at the scale of the entire town. Please do not do this. It is unreasonable and unjust. Thank you.
Thank you. Our next speaker is Miles Tasker. I'm sorry, I think it's Tasker. I'm bad at reading sometimes.
Hello, everybody. My name is Miles Tasker, and I am currently and have been a resident of Los Gatos since the 2nd grade. I'm also speaking on behalf of the Los Gatos Anti-Racism Coalition. So growing up as a member of a low-income family, I can say that rent was probably the foremost economic issue that we faced. There were often times that we failed to pay on time, or times where we failed to pay entirely, and that forced us to move quite often. However, my parents fought quite hard to keep me in this community, specifically because Los Gatos is so exceptional in its quality of life and education quality, which has helped determine me into the professional I am today. And I would ask you to consider the ability your town has to uplift people of lower economic class. I would say that despite being grateful, I'm somewhat saddened because of how much my parents had to sacrifice to keep me in this town. I would say the clearest way to get to a lower rent cost would be developing denser, economically sensible housing. Thank you for your time.
Thank you. Our next speaker is Ronald Meyer.
With respect to the state laws that have been passed over the last couple of years as it relates to the housing element, I see a great deal of risk to the town. And I'd like to see assessments of these state laws as it relates to the risk associated with the completion of our housing element. I have a different perspective relative to the housing element process than Mr. Moore over here. I see the fact that we spent $180,000 with the previous consultants, and we wasted almost a year and a half time to produce 3 failed housing element plans. We then finally came to the conclusion that this consultant wasn't going to get the job done, so we fired him after spending $180,000 and all that lost time and not being able to produce a compliant housing element. Staff has the responsibility, and then the council has the oversight responsibility to ensure that staff is doing their job. So I hold both the staff and certain members of this council responsible for the jam that we're in right now, relative to the risk to the town of not getting a compliant housing element submitted to the state in time to get us out of the risky situation we're in. So I have a different perspective. Do you have $180,000 in your pocket you'd like to maybe donate to the town to replace that $180,000 that was wasted, along with the lost time, which can't be recovered? I think you're coming to a conclusion without the facts, and those are the facts. Thank you.
Thank you. Our next speaker is Sandra Livinghouse.
I am Sandra Livinghouse. I'm a Los Gatos citizen. Thanks so much for having this forum. It's been very informative and useful for looking at the laws. I too am concerned about the process here for getting a certified housing element. It's been a number of years, and I can quote an article here from Mayor Risto last December. Not having any housing element adopted by the 31st puts us at risk for the builder's remedy. Mayor Maria Risto said, we're in a whole different landscape now, and I think our public has expressed concern over that. So that 31st was January 31st. We are now in September. We have no certified housing element. And so my question is, and I did think I would be able to ask a question in this forum, not just speak. But my question is, does the town hold a different opinion about the applicability of a builder's remedy other than the state? And how will this difference be resolved? So I hope you'll address this at the end when you're talking questions. Thank you.
Thank you. Our next speaker is Mike Mayton.
Hi. I'm really concerned about the echo there. I'm really concerned about the fact that the town doesn't have this approved housing thing. And I thought, as well as a lot of other people, that the North 40 was going to solve all of these problems. And yet it apparently doesn't. And I'm wondering why it doesn't. This kind of builder's remedy thing that's going on, it just seems like the builders are coming in and steamrolling all over the town. That map up there with the zoning, I don't know what you guys were planning for revising that zoning in there, but that's been kind of stable for many years. I think the residents of this town like it the way it is there. Okay, I'm referring to these new projects coming in, like the school site in Bellwood, with all of its issues that happen. So there was a question raised by Mr. Moore on CC&Rs in there. And, to further elaborate on that, what if CC&Rs specify lot sizes and setbacks? And we're talking about a 20% affordable housing rate in the project, not 100%, which I believe can override a CC&R. But can the town rely on those for managing this process? Everyone's already said the other issues, so I'll end it right there.
Thank you. Our next speaker is Alba Levitas.
Hi, I'm Alba. I also live in the Bellwood neighborhood. I have 3 kids. They cross Blossom Hill every day, and my heart is this big every day, and they cross multiple times. One of the things that I want to say with this new build of the house is we are increasing 10% the population in a neighborhood that already have a problem. We are increasing the number of cars because the school now was rented to another school that's increasing. It's triplicating the number of students. So we are increasing in every single sector of the neighborhood, the number of cars, the number of people. What I would like to know, if there is anything that we can do now, earlier, while this process is still in scroll, is there anything that we can do to negotiate or to stop? Because once he buys that land, we can see here that we cannot do anything. Is there anything that we can do before that he decides to buy, the developer decides to buy? It got approved, but is there anything that we can do before? Because we will be with our hands tied once this process goes through.
Thank you. Don't see questions. Tony Ellercon is our next speaker.
Council and Commission, Tony Alarcon. I'm actually a realtor. Lived in town since 1992. I think we have a tough road ahead of us. Sounds like a lot of doom and gloom. I do want to share some good news. I have been told that there's legislation coming that will amend from the state of California and give small towns like us more rights to build more moderate housing and not such the number of housing that we're being put on us. 1,993 units just this go around. What's the next go around and where are we going to put them? That's the big problem. Not talking about specific projects. I attended Summerhill's meeting at the Los Gatos Lodge. They want to put 158 units. They said the town allocated it for 250 units for max density of 30 units per acre. Across the streets, 52 units at once going on Alberto. I have been in development in 2007, I believe it was. I looked at buying the lodge to develop it. It failed in traffic calc studies because it wasn't safe. The state of California removed those requirements for builders. The biggest thing is, and Susan asked the question, is there something that we can do to stop certain projects? And in the slide, I do have a question from Ms. Katz there. I believe that fire trumps findings from the fire department trumps builder's right, builder's remedy to stop a development. Specifically, I'm most concerned about the Alberta Way and Highway 9 path because I live in Upper Johnson. We're in a high fire zone, and we're ready for, I hate to say it, but like a Lahaina type event. If there's a fire in the hills and we have a wind, which we often do, there is no way for us to get out. We've instructed our kids, they're gone now, but to ride their bikes to get out. And I hope the community will do a mock fire safety exit. Let's do it when school's out because you can't get out. And let's see how that would affect that particular development. So that's the biggest concern that I have because we're not going to be able to exit down Los Gatos Boulevard. We're not going to be able to go downtown. I would like the town to look at, I'm concerned because the density being put on, I would like the density to be put on locations that are not in the core downtown so it doesn't exacerbate traffic and doesn't increase our safety risk because we talked, I think lawsuit and litigation was said probably 40 times in the opening of this meeting. And if you want to see litigation, real suits, overbuild and have a fire sweep down the hills and have hundreds of people get killed because that's where we're headed towards if we don't stop and reallocate some of the housing elsewhere. Thank you.
Thank you. Our next speaker is Lee Fago. I'm sorry, I think we have a question for the speaker or for staff? Okay, from Commissioner Thomas.
Hi, thank you. You said that you believe the fire department findings trump state housing laws. Is that just how you feel about it, or have you actually seen some attorneys or towns argue this and litigate in court successfully?
It's I was told that a specific development site, if it is not safe due to fire exit emergency access for residents to leave, then that site is not eligible for the development that would cause that harm. And that's what I was asking if the attorney could comment on that to validate it.
Okay.
Thank you. And by the way, speed bumps do work. They put them on
Actually,
Johnson.
that's
You
end of that
answered my
topic.
question. Thank you.
Okay, Lee Fago.
Good evening, and thank you all for taking the time that you have, not just this evening, but in the past, as you have worked together to support our town. Appreciate it. I'm speaking tonight as a resident of the town for 26 years, not representing any group. although I would endorse the words of the previous speaker specifically on safety and safety requirements in new housing developments that the town needs to incorporate into its rules, ordinances, whatever, on safety. I have lived my wife and I, over the last 46 years, in 11 different municipalities in 4 different countries. And we have been here for quite some time. We love it. We're not moving. I'm not leaving unless I'm in a casket or in handcuffs. I love it here. And we need to act more expeditiously and transparently as an organization, both the council, the staff, and I believe the committees and commissions have been, but let's be a bit more transparent in what we're doing. And this will get the community more engaged and supportive. Regarding the, and again, with the previous speaker, just coincidentally, I attended that same development proposal from Summerhill at the Los Gatos Lodge, and my concern was safety there, in that there is only going to be one way in and out of that development. And I believe that the town needs to put into the requirement that there be multiple access for emergency vehicles in and out, as well as for residents to get in and out. Their only other proposal was that they're going to have a pedestrian way to go back towards the high school, but not a vehicle access. So I think the town needs to take a look at how to incorporate that requirement in new developments, that safety is critical. So please consider that as you go forward. And with that, thank you again for the work that you're doing. Appreciate it.
Thank you. Don't see any questions. Lee Quintana.
Good evening. I just have a couple of questions that I would like clarification on so that I understand the laws a little better. We talked tonight about the state's density bonus law. The town also has its own density bonus law. And so my question is, one, is the town's law ordinance consistent with the state law? And two, if not, will the town be amending its ordinance to be consistent with the state law and not have 2 separate ordinances that cover the same topic but do it differently? And secondly, the Martinez versus the City of Clover was mentioned, and I'd like some clarification on that as well. My understanding of that judicial judgment was that an overlay zone cannot allow the underlying less dense existing zoning or the density proposed by the site inventory. But that the thing that I'm not clear on is whether or not that judgment also required that the minimum density as stated in the site inventory be met, or whether projects can come in at lower densities.
Thank you.
All my other comments on the housing element will be made later.
Thank you very much. Our next speaker is Mitzi Anderson.
Hi, my name is Mitzi Anderson, and I'm a resident of Los Gatos. And I had a question for understanding. If the town had adopted a substantially conforming housing element by January 2023, would the builder's remedy even be a consideration? That's my question. Thank you.
Thank you. And we'll be getting to that. Our next speaker is Bryce Watt.
My name is Bryce Watt. I'm a reasonably new member of the Belleville community. I've been there for about 3 years. I'd like to say thank you for actually speaking to us, like you previously mentioned. The Union District didn't really want to talk to us. We were actually going to vote on selling land beforehand, so I really do appreciate you guys actually willing to communicate with us. I have a quick question. When you guys were talking the density bonus, if the lot size is supposed to be for 10,000 square feet, and you're talking about a density bonus, would that only reduce it by at most 20%, or I think that's what they're referring to? I'm assuming you'll answer that at the later question, right?
So staff will review all the questions during the break, and then we'll answer them after the break.
That's our way to keep you here. Okay, thank you. We're here, you're here. Or you can watch us on Zoom. Our next speaker is Jack Venata. Sorry.
Good evening, Mayor, Vice Mayor, Planning Commission, Council, and staff. I just have a question, and I know the answer will come later. The residents were told that by adopting the housing element by January 31st of 23, the town would prevent builder remedy applications from being filed. Currently, there are 4 pending applications, all using SB 330, with perhaps 2 to come. One builder's remedy, SB 330 application, is for a 5-story building in the downtown park, replacing the current post office building. How can this happen if the town adopted a housing element that was substantially compliant with state law by the January 31st, 2023 deadline? I'll get my answer later. Thanks.
Thank you. Our next speaker is Calvin Louie. I almost thought that was a C.
Yes.
Okay, Calvin Louie.
Yes, thank you very much. Yes, I am Calvin Louie, and I've been a resident of Los Gatos for 38 years. And I just want to address one of the speakers here, is that when I first moved in here, I'd say probably the makeup of the town would be primarily not many from Asia or any other country. I'm going to say that my neighborhood now is largely made up of people from all over the world. So I don't like the allegations or intimation that there's somehow racism in Los Gatos. It isn't. It's a very friendly town, and the makeup, like I said, is from all over the world. That's just one of the points. I just want the people to know that you don't have to keep raising the issue of racism. It offends me. Number 2, my understanding is that the state had a regional housing needs allocation, and the state had mandated 1,993 units. One of the questions is, how long does it take for the state to have to build that many units out? The other issue is that my understanding is the town, instead of meeting the state minimum requirement, has proposed initially to build 3,904 units. That's my understanding. I just want to know more about that. And once again, is there a planning commission recommendation that's less than the 3,904? But I want to know why we are trying to build more than the state minimum requirement, because I do like what Susan Burnett has said, that if the infrastructure of Los Gatos is not capable of taking this many units, then what are we trying to do? Overbuild. And I'd like to know, what is the benefit of overbuilding to the people of Los Gatos? I mean, truly. We have concerns that you've heard of from the people here. Congestion, traffic deaths, and our infrastructure can't take it. So I want to have a better understanding of who has the power to vote on this excessive building to explain why we're doing that. All right, thank you very much.
Thank you. And I think we'll get back later to what a buffer is. And this isn't a housing element hearing, but we can answer those questions. It looks like I have all the cards from the room. So if anyone else wants to speak, and I've got a number of speakers on Zoom. So my next speaker will be Sutton. And Sutton, you should be able to unmute yourself and speak for 3 minutes. Thank you.
Thank you. I really appreciate Barbara Katz and the explanations we heard tonight, explaining what was going on with the state and all of these new regulations. I'm also very big on transparency, and I think it would be very helpful for the residents to understand the critical dates for getting certified housing element, and also what penalties are there and when would those apply? Additionally, I would very much like to understand some of the very low, and moderate income. I heard Barbara say that 30% of 60% of the median income was for lower income. I'd like for somebody to put numbers to that so that we could all understand what is very low, what is low, and what is moderate housing costs. Additionally, I mean, we all understand that there's a need for measured growth and affordable housing, and we want the city to certainly accommodate that. What we don't understand is increasing the density of luxury housing at the expense of affordable housing. So that's pretty much what I have to say. Oh, one other thing. I heard Barbara say, I think it was on one of her slides, that water and sewer, having sufficient water resources and sewer resources for the developments was essential. Have we ever done a study on water and sewer? And do we know how many units and how many new folks we can accommodate in the town? That would be something that I would very much like to know. Thank you very much.
Thank you. I don't see any follow-up questions for you. Our next speaker is Bill Kraus. Bill Kraus.
Hello, Bill Kraus, longtime Los Gatos resident. First, I want to agree with Mr. Louie. I heard the speaker say the Diddle Lane was opposed for racism, and I supported the 22-unit Diddle Lane project that was championed by Bud Lortz for the town of Los Gatos. And unfortunately, the people I talked to who were against it, they cited the traffic and the parking on that narrow one-lane road going into Diddle Lane. I'm sure there's racism and too much. 1 is too much, but let's not, that's enough on that topic. I didn't see it in any of the people I talked to, and I'll leave it there. My comments. Can existing traffic on streets be an objective standard for limiting development? And I say that both for standard traffic and fire evacuation traffic. Can we make objective standards that limit development on roads? And I think that would be the Bellwood people would help them out. And another thing is, with all these really complicated state laws and regulations, the town staff may have a hard time staying on top of them and knowing the facts that would most protect or the laws that would most protect the town. Can the town require higher fees for some of these special applications like builder remedies to cover the fees for consultants or attorneys that would assist staff, sometimes on an expedited timeline? And that way they could use the law as much as possible in the town's favor. Thank you for all your hard work. Let's focus on the housing element, get that done. And again, thank you for all your hard work.
Thank you, and thank you for your comments. Our next speaker is Nika S.
Hello. I kind of wanted to talk from a personal experience point of view, and just tell an anecdote from my life that describes, a need for affordable housing. Around like 2008, my dad lost his job due to health reasons, and my family was unable to continue living in the house that we were living in Los Gatos. And as many of you know, 2008 was also the year of the housing crisis. But at that point, my sister and I had already, you know, attended school in Los Gatos and made friends, and our roots had already been established. And for the next 7 years of my family's lives, in order to maintain our position in Los Gatos, we had to bounce from house to house, trying to find something that was temporarily affordable or that was appropriate enough for our financial situation that my parents could continue to raise my sister and I in Los Gatos. Because, I think a really valuable part of our town is our schools. And that was something that they were not willing to let go of. So it was a pretty harrowing and difficult period of our lives because we never had one home. We were just, every 2 years or after a year or however long we would have to move because the rent would change or we could no longer afford to live in that home or our situation would change. And I know for my family, this really impacted our ability to feel part of the community in Los Gatos. And I think that affordable housing is a really important part of providing access to, a better education, a better living situation, a better quality of life for people such as my parents who immigrated to the US and don't exactly have the strongest of roots or generational wealth, but are still, attempting to work and survive in society and provide the best lives that they can for their children. And I just know that if that had been an option for my family at some point, the last 18 years of my life and my sister's life would have been a lot easier growing up in Los Gatos. So I think that, statistics that describe firsthand truly how segregated our town is, those are not just numbers, those are
Thank you, Nika.
lived experiences.
Thank you. Our next speaker is Jake Wade. And Bill Kraus, you can put your hand down because I won't be able to be calling on you again. Thank you.
Hi, hello. My name is Jake Wild, and I've lived in the neighborhood my entire life. And I want to echo some of the great comments I heard made by the members of the Anti-Racism Coalition that spoke earlier. The very purpose of planning and zoning in the United States has been to classify the population and segregate them according to their income or situation in life. And that comes from the Euclid v. Ambler ruling from 1924. And today, Los Gatos is the 7th most segregated town in the Bay Area and has the 4th and 5th most segregated neighborhoods in the Bay Area. A robust housing policy is necessary to achieving a vision of integration. Additionally, the housing market doesn't really abide by our mess of municipal borders that we have all over the place. It's a regional issue. And I would like to see my town of Los Gatos do its part to build more housing alongside the rest of the region to give young people like me a future here. To quote another former Bay Area mayor, regional responsibility doesn't sound as sexy as local control, but it should be the rallying cry. So I would like to see Los Gatos work alongside the state to go above and beyond those demands for housing. Thank you.
Thank you. Our next speaker is Sandrine Chalmette. Sandrine, you should be able to unmute yourself. Okay, I'm not seeing her unmute herself. I'll give you another chance in a moment, Sandrine. Let's go to Jim Lyon.
mute. There it is. Okay, I believe you can hear me now. Thank you. Thank you for all the hard work that the council, the planning commission, and staff has done on housing. I know it's a very challenging issue. I'm a lifelong resident of town. My parents actually bought a lot in Los Gatos, a 1-acre lot in 1959 for $3,000. That was when Los Gatos was affordable. And I find that, this is a very challenging, situation you're in. I mean, I'm looking at, putting an ADU on my property to create affordable housing, but the cost is outrageous. You're talking about $500,000 to $600,000 for a garage and an ADU combination, freestanding. How is that affordable? I mean, the cost of construction is outrageous in the state, and it is something that, while we want to create affordable housing, is it really doable? I think there was a comment by Commissioner or by Council Member Badame around infrastructure, and I think that's very, very important. This idea of providing infrastructure, roads, traffic, schools, and the overcrowding issues, water and sewer, town services, police and fire safety. How are we going to pay for all of that? As the town continues to lose sales tax revenue by conversion of commercial spacing to housing, how is that made up? Does the town receive property tax revenue? The county certainly does, but what does the town get from that? How are we going to pay for that? So I think that there's major concerns in terms of conversion of commercial to residential, and how do we sustain the town, and then the whole infrastructure and safety issues, as Mr. Alarcon mentioned. So I do thank you for working on this problem. It is not an easy one to solve, but I think if we work as a community and find reasonable housing solutions rather than just letting developers jam things down our throats, we can come up with a successful, basically, solution to this. Thanks.
Thank you. Our next speaker is Ellie Miano.
Hi, thank you for taking my comment. Although I'm a member of the Complete Streets and Transportation Commission, I speak to you tonight as a private citizen and a member of the Los Gatos Anti-Racism Coalition to advocate for affordable housing. It's come to my attention that some members of the town council have called for quote unquote reasonable housing development in our town. But reasonable is a relative term. Is it reasonable that our state has the most unaffordable housing in the country, and not coincidentally, the highest rate of homelessness? Is it reasonable that half our country's unsheltered population, as reported in a recent study by the University of California, San Francisco, reside in California, that 90% of our current homeless lost their housing right here in California? And did you know that 75% actually live in the same county where they lost their home? Is it reasonable for California, Santa Clara County, and Los Gatos to turn our backs on these folks, as we have continuously done for decades? I don't know about you, but I don't call that reasonable. I call it inhumane. All over town, we have vacant buildings, like the old museum at the end of my block, like the businesses that seem to close up shop on a monthly basis. Yet we have unhoused people sleeping in creeks and parks and next to freeways. Is that reasonable? I hardly think so. Every human being should have a right to clean, safe, affordable shelter. This is a homegrown problem in need of homegrown solutions. We need affordable housing. Since California requires that only 20% of a given development be offered at below market rates, which isn't necessarily affordable in California, by the way, that means we need more housing and more dense housing in order to get sufficient, hopefully, affordable housing. So here's what I would call reasonable. We have to do the math. Do we want to blow up the burgeoning homeless population of our town, our county, and our state? Or do we want to do what's not only humane, but better for the entire community? If we help the unhoused, we help everyone. We have safer, happier, healthier communities where everyone can thrive. What good is it to build more McMansions when your neighbors are increasingly unhoused, squatting in vacant buildings with no heat or water? That's the reality of some members of the town council that they want to paper over as reasonable. And in reality, it's unreasonable, it's irrational, and yes, it's inhumane. Thank you.
Thank you. Looks like the final speaker I have is Kinsey Lee. Whoop, another hand went up. Okay, Kinsey Lee and then one more.
Hello. Hello. As a current resident of Los Gatos and a member of the Los Gatos Anti-Racism Coalition, I want to voice my opposition to decreasing the number of housing units in our housing element. Upon review of HCD's letters dated January 12th and May 30th, I saw no suggestions to reduce our proposed units. HCD sees overall housing and thus density as directly related to affordable housing. In both their finding documents, they note 20% of all units must be affordable to lower income households. On several occasions, the reviewers actually expressed a desire for more in-depth analysis on factors that would directly impact, quote, the ability to achieve maximum densities, unquote. As such, calls to dial back the initiatives set forth in our housing element seem only to be rooted in a desire to preserve our community in some intangible way. I understand the sentiment somewhat. My parents sought out the small town nature of Los Gatos roughly 2 decades ago. They hoped the warmth of the people here would support their rather socially withdrawn child at the time. And I'm glad to say that worked, mostly. My first grade teacher still remembers my name. I have lifelong friends from down the road. I'm here publicly speaking at our town council meeting, doing my best to pay that kindness forward. As a member of this community now, I'm here to advocate for its growth because I don't believe this small town's charm needs to be predicated on exclusion, on a fear of us versus them, a competition of resources. I don't see how welcoming others to Los Gatos or giving them the space to flourish would do anything but strengthen our congeniality. Therefore, I support the development proposed in our current housing element, nothing less. Thank you.
Thank you. And my final hand on Zoom is Sandrine. Okay, you should be able to unmute yourself.
This is
Yes.
Sandrine. Can you hear me? Great.
Yes, we can.
Hi, I'm Sandrine Chomet from Los Gatos. I've been a resident here for 30 years, and I've raised my 4 children here. What I'd like to say is brief. We need to respect our essential workers like teachers, firefighters, police officers, healthcare workers, and more. Currently, these workers have to commute 2 or more hours each way to take care of the people of Los Gatos. While you may not care about the quality of their lives, remember that's going to affect the quality of your life if they are exhausted from the long commutes or basically not invested in the town where they work because they don't live here. It becomes just a job. So what I'd like to say is we need more housing. If more density is needed, then that's what we need. Please do not water down our existing housing plan to reduce housing development in the future. Thank you.
Thank you. Whoops. All right, I have one more hand on Zoom. Albert Lustre.
New guys coming in, they're doing it 8 months more, not a 12 months.
Good evening, City Council and Planning Commission. My name is Albert Lustre with the Carpenters Union Local 405. And I just want to say thank you for the time, for taking the time to review those bills. One of the things I want to talk about is the need of more focus on the AB 2011 and the things it offers for the community as far as the construction workers, which includes apprenticeship, local hire, and healthcare. And just look into that to promote any future development. And thank you for your time.
Thank you. All right. Seeing as I have no more cards in the room, and I know sometimes people on Zoom, they've had plenty of time to raise their hand. So I'm going to close public comment. So let's see. I've got 924 right now. We did have a lot of issues covered, especially, most of these were focusing on the housing laws, but I think there were some questions that came up that our staff will be able to look at. So 924, do you want 10 minutes or 15? I want, with due respect to staff, I want to make sure they have time to consolidate the questions and be able to answer them.
I think 10 minutes would be sufficient.
Okay, so at 9:35, we will reconvene. If anybody lives within 10 minutes and they want to go home and watch the rest on Zoom, I won't be offended, but anyway, we'll reconvene in 10 minutes. Thank you. All right, thank you, everybody. It looks like quite a few members of our public went home to watch this, and that's fine. In addition, this meeting is being recorded, so you can watch it later. But I do appreciate those of you who are hanging out with us, and I appreciate, while the rest of us were all chit-chatting, that our staff was actually working hard to compile the issues and questions that were raised. And so at this point, I will turn to staff and let you organize yourselves. And I think it looks like our town attorney will delve into the issues.
Yes.
So thank you.
We talked about who was best equipped to handle each question. And so we'll rotate amongst ourselves answering the questions. The first question is, how does the town handle transparency with regard to planning applications? Is there always an environmental impact report? Is there always a traffic study? And who pays for those things? And so Jennifer Armour, the planning manager, will be addressing that question.
Thank you and good evening. Jennifer Armour, planning manager. So first, in terms of transparency, what we'd like to share is that we do have a lot of information on the town's website. If you go to the Community Development Department's page, there is a link to our state housing laws. And so any of these preliminary applications that have been deemed submitted under SB 330 are listed there. Once a formal application comes in, it joins all of our other pending planning projects on that page. So those are available online. In addition, the Housing Element Update website, also available through the Community Development Department, does include a timeline for those who were interested in the current timeline for getting through our Housing Element Update process, as well as getting through the rezonings that we discussed earlier. In terms of individual projects and environmental review and traffic reports, these are part of the review process. And as we discussed this evening, most of these projects, CEQA, the Environmental Quality Act, will apply to the project. Whether in most cases an environmental impact report won't be required, a lower level environmental review will be involved, but that will be part of the process and part of the staff technical review that is done as part of any of our development process to determine what level of environmental review is needed. When appropriate, based on the town's policy and standards, a traffic study may be required. That is something that is part, again, of that development review process. It is reviewed and in some cases peer reviewed by the town's consultants as part of that process. But it is, many of those studies end up being required to be provided by the applicants for these projects. I think that covers those initial questions, but also for individual projects, we will have contact information on the website once the project becomes active, once it's a pending planning project, for a property or a planner who will be managing the process. And so that's somebody you can reach out to, any member of the public can reach out to with questions and to keep up to date on the status.
Thank you. And it looks like we have a question from Councilmember Hudes.
Thank you. Relative to those pre-applications and formal applications and everything under SB 330, do we anticipate having public hearings at the Planning Commission and the ability to appeal to the council on things like architecture and site and other things that are typically part of our traditional review process? So will there be public hearings on any of these?
Thank you for that question. Yes, these projects, so far as we understand them at this point, are expected to go through our standard architecture and site application process, and we do expect that most of these would go to Planning Commission for determination, and any decision of the Planning Commission can be appealed to Town Council.
Thank you.
Next, there were a series of questions asking how the issue of the town's housing element substantial conformance with state law will be resolved with regard to builders' remedy projects. And so this would be resolved ultimately, if a project referenced the builder's remedy and were denied by the town, and the parties had a disagreement over whether the housing element substantially conformed with state law, ultimately that would be determined by a court. I did want to reiterate that regardless of the builder's remedy, Senate Bill 330 and the state density bonus law will still continue to apply to planning applications that the town receives. The next question was, why didn't North 40 solve the town's problems with regard to its regional housing needs allocation? Phase 1 of North 40 was built prior to this housing cycle, and so those units won't be counted for this housing cycle. However, any units in Phase 2 will be counted during this housing cycle.
Can I ask a question
Yes.
about that? So, however, Phase 1 was done in the last housing cycle, and we had a RENA number of 619. So, I guess the question is, did Phase 1 of the North 40 go into the last housing cycle and help us meet our numbers or not?
I'll have to defer to either the director or the planning manager.
So I'll start, and if Ms. Armour has anything to add. So it varies. So the state lets us take credit for the units when the building permit is issued. So we still have some buildings that haven't been issued for the first phase. However, we're learning some new opportunities with our consultant where we may be able to count multiple times between last phase and this phase for the last 6 months or so of 2022. But we're still working through those logistics, but the majority of them were counted in the phase, the 5th cycle.
Okay, thank you.
The next question had to do with density bonus projects and what happens if an applicant seeks a waiver from the town's development standards and yet private CCRs specify lot sizes and setbacks. And so the CC&Rs are private agreements, and those would be enforced by private parties. The town would not be involved in enforcing the CC&Rs. The next question was related to the first question about transparency, and it was a question about how residents can be involved with particular projects that may come before the town. And so the answer is similar to the answer that the planning manager gave initially. Those will be processed as planning applications, and so there will be opportunity to attend public meetings and provide public comment on those projects. The next question was whether fire safety standards trump the builder's remedy. And as Ms. Couts outlined, there are 5 potential reasons that the builder's remedy would not apply to a project. One of those reasons was that the proposed project violates health and safety standards. And as Ms. Couts described, those health and safety standards need to be objective and codified at the time that the planning application is deemed complete. And so it will depend on whether or not, if it's a fire standard that is both objective and codified, it will apply. The next question had to do with the town's density bonus ordinance and whether or not it was consistent with state law. Currently, it is not consistent with state law, and the reason for that is that the density bonus state law has been amended pretty consistently on an annual basis, and so the town, needs to keep up with changes to the state law. When there's an inconsistency, the state law governs. And I will say that staff is working on an update to the town's density bonus ordinance, and I know that the goal is to have that in place prior to the end of this year. And then the next question sought clarification on the case of Martinez versus the city of Clovis, and so Ms. Couts is going to address those questions.
So Clovis had adopted an overlay zone to meet their lower income housing need. It was pretty high, and they basically adopted an overlay zone that I think provided for a range of something like 35 to 50 units an acre, something like that, to accommodate their lower income housing needs. But it was an overlay zone over a single family residential zone. And so it would still be possible for an owner to build single family homes rather than to build at the minimum density that was specified. And so the court said that the housing element law requires that if you do an overlay zone, that any development has to be done at a minimum density of 20 units an acre. And because the way Clovis had designed its overlay zone, someone could still build single-family homes at quite low densities. It didn't meet that requirement to have a minimum density of 20 units an acre. My understanding is that the city is designing its overlay zone to meet that requirement so that you can't build in the underlying zone at less than 20 units an acre.
Next, there were a series of builder's remedy questions. One question was whether the builder's remedy would apply if the town had an adopted housing element that HCD had determined to be in substantial conformance with state law by January 30th, 2023. And the answer is the builder's remedy would not apply in that instance. We do have some applicants who may argue that the town's adopted housing element is not in substantial compliance with state law. And I'll just reiterate that under those circumstances, like Senate Bill 330 and density bonus law continue to apply. And then we had a density bonus question. Can an applicant use a density bonus waiver to seek to modify the town's minimum lot size? And the answer is yes. An applicant can seek a waiver for any development standard that the town has, and minimum lot size is one of those development standards. Next, there was a question on how long the town has to build the 1993 units that were allocated to the town by the state. I wanted to clarify that the town itself is not responsible for building those units. The town's responsibility is to zone enough sites appropriately so that it's possible to build the 1993 units. And the time in which the town needs to accommodate those units is the 8-year planning cycle that will be covered by this housing element. And related to that question is why the town had adopted a housing element that provided for a number larger than 1993. And the town's planning manager is going to address that question.
Thank you. So for that one, it really does tie back into the justification. The key here, again, is not building the number of dwelling units, but providing an inventory to HCD, the state, for review with the proper justification, and buffer is part of that to justify the number of units that they require as part of our RENA could be built within this 8 years. In addition to this question, I did also want to provide one bit of clarification. We've got a number of different parts of our ordinances that we are working on updating for compliance with state law. The one that we are working to complete by the end of the year is our accessory dwelling units ordinance. We are also planning to work on updating the density bonus ordinance. That is one of the implementation programs in the housing element, but that doesn't yet have a timeline. Thank you.
Next, there was a question asking what is the critical date for getting HCD's certification of the town's housing element. And, as the Planning Commission and Town Council probably know, it's desirable to have that happen as soon as possible. And so that's what staff is working toward. And there was a related question to what are the penalties. And I think the penalties will come into play if if HCD gives the town direction and the town takes too long to implement that direction, and then a court orders that and the town still fails to comply with the court order. Next, there was a question regarding what constitutes low or moderate income housing, and there was a request to put numbers to that classification, and so Ms. Kautz is going to address that question.
So, so the maximum income for someone to be considered low income in Santa Clara County, these are pretty high numbers. For a single person, it's $96,000 a year. If you make less than $96,000 a year and you're a single person, you're considered low income. And a household of 4 that makes less than $137,000 a year is considered low income in Santa Clara County. My sister in Madison, Wisconsin would die. The maximum rent for a studio apartment, using the formula in the statute I was reading, is $1,900 a month. And the maximum rent for a 3-bedroom unit considered low income in the statute is $2,700 a month. So these aren't actually that low, either incomes or very low rents.
The next question was related to why so much luxury housing has been proposed, and the town has the ability to impose a requirement for affordable housing in a specified percentage, but it has to be such that it would still provide an economic return to the applicant. And so the town has settled on a range of between 10 and 20% affordable units. And so that's what the town has in place. A requirement that developments be 100% affordable would not be legally defensible. The next question had to do with how does the town know whether there's an adequate water or sewer supply for proposed housing? And the planning manager is going to address that question.
Thank you again. So this does tie back to the environmental review that was prepared. So as part of adoption of the housing element earlier this year, there was a environmental analysis that was prepared and it did confirm that the housing element as proposed fell within what was considered for the general plan, the 2040 general plan, EIR, and therefore could proceed without any further impacts. It did consider sufficiency of water and other utilities for the development that was considered in the draft environmental impact report.
It looks like we have a question from Councilmember Hudes.
Yeah, this one troubles me because the EIR did not reference the fact that the largest reservoir, the one that contains more water than all the others combined, is out of commission for 10 years. And also didn't reference that there was a mandatory water reduction on households. Are those factors in terms of understanding whether there is adequate water supply when those conditions apply? I just don't understand how an EIR could miss something like that and still be certified.
Thank you for that question. The environmental consultants do look into a number of sources for information to assess the availability of different utilities. So that includes water. It also includes things like capacity within the for disposal of waste and other things. So there is a standard practice for reviewing that, and they did find that there was sufficient. It may be that our town manager or community development director may have something to add as well.
Let me just add that the water agencies are required to do an urban water plan. So that means they have to consider all of the general plans for all of the communities within their service area. And then it becomes the basis for the water supply analysis. And under state law, they're required to update those plans and continue to consult. So when the town does its own EIR, we rely on the agencies that are responsible for their respective infrastructure to do the data analysis. And then, of course, they also comment on our EIRs if they feel that our consultants missed something from their technical reports. So we coordinate very carefully, and they're heavily regulated in this arena.
Follow on? Okay.
Yeah, so I'm just asking if the water board is mandating a 20% cutback, does that mean that they have adequate supply? And if an EIR fails to recognize that half of our water supply is offline for 10 years, are those grounds for challenging the EIR, and is that the right way to bring up the issue about denying something on the basis of having inadequate water?
So thank you, council member. I'm going to start, and I think it's really going to involve staff doing a couple things, going back to the EIR, going to the most recent urban water plan. Obviously, the water agency has known that dam was going to be needing repair and out of commission for months. So I know they often will look to other sources to make sure that they can bring as much adequate supply as they can. And we'll also look into it to see if their urban water management plan contemplates or anticipates the 20% reduction, and we can also follow up with them directly.
Thank you.
The next question asked whether traffic concerns can ever constitute an objective standard. And so Ms. Couts is going to address that question.
In general, certainly traffic concerns can be traffic standards can be an objective standard. In terms of whether they're a health or safety standard, though, clearly some traffic standards are related to safety. At some point, you need a stop sign, to make a street safe, or a merge lane may need to be a certain length, all those kinds of requirements. I think it would be questionable whether mere traffic congestion would be considered to be a health or safety standard, however. But it is possible to develop traffic standards that are objective and can be used to evaluate projects.
Councilmember Hughes.
So a number of residents raised the issue about only one way in to a development. And I know, in fact, in one of those developments, we were able to successfully negotiate widening that street on a previous development. Are those areas that that the issue of safety can be used to negotiate a better development?
I think that let's see, it would depend. I think if some kind of environmental review is necessary, that could be a mitigation measure. If, though, the project, if you need to rely on objective standards, you would need to have some standard adopted in advance that would, require either an additional access point or the widening of the street. Yeah.
And the final question was whether the town can require higher processing fees for planning applications that involve a high degree of review. And the state law provides that the town can recover its costs in processing planning applications. And so the town can impose processing fees that reflect the cost of reviewing applications. The way that works is the town would average its costs to review all planning applications in the town, and then would adopt a fee in the town's master fee schedule that reflected the average cost that the town expends on reviewing planning applications.
Yes, so Chair Burnett.
Could those costs include outside counsel?
Yes.
Okay, thank you. So staff has concluded answering the questions that were raised in the public comment.
Yes.
And I appreciate that. There were a lot of things that came up, and the way you put them together and answered them is extremely helpful. So now I'll turn back to my fellow council members and commissioners for follow-on questions. Council Member Rennie.
I think I have two at this point. Let me explain my question a little bit. You didn't mention the no net loss law. When we're planning our housing element, we put together, we figured out what sites we want to try to cover all of this planned building we're supposed to plan for. If a project comes in below what our plan was, it creates what's called a net loss, and we now have to, if there's less units, we now have to go find more sites than were originally in our original housing element, and I think we're trying to focus our development in our potential development in certain areas. So having to go find more sites can be painful. And so getting developers to develop to some minimum density on these sites so we don't have as much net loss. So that's the backstory. The question is, we've got some sites where we want to put in a minimum density of 30 units. And you mentioned there was a rule that it has to be built at least 20. If we have a zoning of 30, can somebody come in with a project that's less than that? A lot of developers believe that building over 20 units per acre is not economically feasible unless you go way up to 70 units per acre, for example. There'll be some that will tell you that. So in some of our sites that we want to have 30 as a minimum, can an SB 30 law or a density bonus application, which of these could actually come in and give us an application less than 30 and we'd be forced to accept it?
I think if, once you have a ordinance adopted with a minimum density of 30 units an acre, I don't believe any of these laws can be used to go below them. The one that we've seen used is the builder's remedy.
What about the concessions that are allowed in the density bonus law? Isn't density a concession? I realize the density bonus law is written to give a bonus when in fact they want an anti-bonus, but it still says if you meet you could get a concession.
It has to be a regulatory concession that saves money. It has to result in identifiable and actual cost savings in order to provide affordable housing. Now, the burden of proof would be on the city to deny it and say reducing the density does not, reduce your costs to provide affordable housing. But people try anything.
Second question. So during our break, I went and looked at the project on Bell Gatos Road, and I noticed that the zoning is public. So can it's currently zoned public. Can a public current zoning be an SB 330 project or even a density bonus project? Because I'm assuming they're buying. So what's happening is they're buying a public piece of property from a school, and it's going to need, I assume, another zoning, but they aren't really vested to anything because we haven't given a zoning. So how is that going to work with an SB 330 application?
Well, all an SB 330 application does is freeze what's there at the time, so it would freeze the existing public zoning. I mean, the arguments, so long as neither the general plan nor the zoning allow residential in the public zone, they would need a rezoning and general plan amendment.
That sounds like it needs to be explored further.
Yes, I think you have to look at exactly what we see developers make very creative arguments that the zoning is inconsistent with the general plan. So you need to really look carefully at what the general plan shows for the site and what the zoning says.
It looks like Manager Armour wants to add in here.
Just one point of clarification for that site that we're discussing. The general plan designation is public. The zoning is actually low density residential. It's in our R110 zone.
Okay. Does that answer your question, Councilmember Rennie? I think so. Okay. Looking around, any other questions, comments? Councilmember Hughes.
Thank you. I wanted to go back over something that was covered a bit quickly, and that is substantial compliance. I assume that substantially compliant and substantially conforming are the same thing. Is that correct?
Are you talking about in relationship to the housing element or to a project?
I'm talking about the housing element.
Yes, essentially they're the same, yeah.
Okay.
I mean, so there's one standard that the courts have adopted.
Okay, so the question was asked if the town had adopted a substantially compliant housing element by January 2023, would builder's remedy even be a consideration? And the answer was, I believe, from the town attorney, was no, it would not be. And so the argument then would be that that housing element was not substantially compliant in order for a developer to be able to move forward with builder's remedy. So we have a series of letters from HCD, and they talk about that our housing element is not in full compliance. They don't, in the letters that we've received, I don't believe they talk about substantial compliance. On the other hand, in the Flint Ridge letter, they talk about substantial compliance, and that was and the builder's remedy. Where are we in terms of compliance? Do we are we of the position that our housing element that was submitted is substantially compliant, and HCD is saying that it's not compliant? Is that the same thing as not substantially compliant?
I didn't follow the last part of the question, but the town adopted the housing element on January 30th and made findings that it was in substantial compliance with state law. In March, the town did receive a letter from HCD that outlined additional changes that would need to be made to the housing element. So it's an open question as to whether or not it is in substantial conformance, and this is probably not the right forum to talk about that. The reason that the town adopted the housing element was in order to preserve its argument that it does substantially conform with state law.
So the Flint Ridge letter, you're familiar with that?
Yes.
In that letter, HCD is saying that the adopted housing element did not substantially comply with state housing element. And that is, their position on that. And then they go through the status of the housing element in Flint Ridge. Are we to take it that the state thinks that we're not in substantial compliance on the basis of the letters that we've received?
If there's interest, I'd prefer to schedule a closed session discussion of this.
All right. I would just add that, coming back to my earlier comment, if we do discuss it, it would be very valuable to have our housing consultant and their opinion about whether we're in substantial compliance. Otherwise, it's a really theoretical discussion.
Okay, and I just wanted to weigh in. I mean, I think somebody read a quote from me earlier on, and at the January 30th meeting, no one, I think, on the entire council or anyone said that adopting the housing element would prevent the builder's remedy. We were minimizing that. We were taking steps that other communities have done to minimize the risk of builder's remedy. And, you know, that could be argued in a court of law if a builder's remedy came forward and we decided to fight it. But on the other hand, it looks like none of the applications we have right now are straight builder's remedy anyway. They're all invoking SB 330, which we could still have come to us even if our housing element is in full compliance. So there's just a lot of open space there. I'm going to, hold on, so I'm trying to think the order I saw. So I'll go Vice Mayor and then Councilmember Moore and then Councilmember Rennie.
So if we could elaborate on that Flint Ridge letter, and I realize that you want to talk about the details of that in maybe a closed session, but I think we could get some comments, or if you could elaborate on the high defense costs, possible damages, and significant attorney fees, should this be a bone of contention. How costly is that for our town?
I guess it depends what lawsuit you're talking about. If you're talking about denying a project that claims the builder's remedy, and there's a dispute about the dispute is whether the housing element was adequate or not, that can be quite expensive litigation to fight because you have a very extensive administrative record, and you all know how long and complicated the housing element law is, and somebody would need to go through. The plaintiffs, I guess there'd be a plaintiff, would need to go through the housing element law and explain all the areas in which they, asserted that the housing element was inadequate. The town would need to go and defend each of those. So that could easily be quite expensive litigation. Hard for me to give you an estimate.
No, but you did. You answered my question, so you were right on the same track as I was. I don't know if you had an opportunity to read that desk item, but that is exactly it. It almost refers to a city or a town, kind of, if you will, call it self-certification of its housing element.
Okay, further discussion of the state law. Councilmember Moore.
Thank you, Mayor. Question about smaller rental units, and I don't know if there's any answer to this at all. But I'm a renter in a small, naturally affordable unit, and Los Gatos actually has a good number of these, but not nearly as many as would be needed to accommodate our working class population. And nothing that we've talked about tonight talks at all about natural affordability or, and I think only SB 35 talked about rentals. And so I'm curious if there's anything in any of what we talked about or any of these other hundreds of state laws that you're aware of that encourage smaller units, and then maybe a second question. I know there are pieces of state legislation that protect rental units, and when you redevelop, and so if you could say a little bit more about that as well.
Let's see. So one was about part of the question was about the laws that protect rental units, so that if someone is proposing. Actually, they're strengthening the legislation, but basically if someone is proposing to, say, tear down your building and build a more expensive building, they must replace at least the total number of units that exist on the site. And if there are any lower income tenants living there, they're entitled to state relocation benefits. They're also entitled to a right of first return, and the developer needs to create as many lower income units as there were lower income households living there before. So even if the rents are not lower income rents, but there's lower income households living there and paying high rents, the developer must create lower income units. So we call those the replacement housing obligations. Repeat the first part of your question again, sorry.
Smaller units, is there anything? Yeah.
Yeah, there's nothing in the state law that really encourages smaller units, except maybe in the ADU statute. But one of my clients, actually, when they upzoned to 30 units an acre, they also adopted a maximum average size for the units. Because they said they didn't want them all to be 5,000 square foot luxury units. Now, someone could ask for a waiver for that, but actually, so far, the developers have pretty much complied.
That's interesting. Thank you.
Yeah.
I'll just share with the body here that, I heard a few times tonight about luxury units and how, a lot of what's being built is, we kind of have this divergence between there's these low income units that are deed restricted, low income affordable housing, and then you have these mega luxury, all kinds of different units. And I think some of that is true. I think there are definitely projects we can look at in Los Gatos that look like that. But one of the examples that I use in terms of my would-be homeownership journey is that the units that sold in the North 40 when the first units that were sold, love them or hate them, I know a lot of people hate them, they were selling for less than $1 million. And $1 million I know is not affordable, in most people's view, but that is within, speaking from, personal experience, that's within my line of sight in the next 10 years of home ownership. The average this month, the average cost of a home in Los Gatos is well over $2 million. And so I think it's important to recognize that a lot of these units that are being built are not the luxury condos are not the be all end all, and they're not what I would love to see in this community, but they are a lot better. They're better, and they're helping people like me and like some of the speakers who spoke, who come from who have it's a 2-income household that can scrape it together, and they're like the starter homes that used to exist. And so as we talk about, the units that are being built, I think it's important to remember that $1 million is actually not bad for a lot of people that are trying to buy a home in Los Gatos.
Thank you. I just want to tail on that. I mean, we've seen articles. A lot of times people use the phrase luxury housing or luxury condos, and we're in an incredibly expensive area. If you picked up what people call a luxury townhome and dropped it into an area where I grew up, a part of Chicago back then, it's not luxury. Luxury is based on the price. It's a regular condo in an expensive market. It's not gold plated. It's not anything. It's brand new housing that was built in an expensive market. And if you picked it up and put it in a less expensive part of the country, it would just be a regular house. So I think that's something else to keep in mind. Okay, hold on. Yes. Commissioner Hanson.
Thank you. I understand that the council may want to have a special study session, but I wanted to pick up on something that Ms. Katz said, which was about the process of the legal evaluation of the housing element. If I heard you correctly, the burden of, if it came to a builder's remedy project and we didn't want to approve it, the burden of proof, it sounds like, would be on the developer to prove that we were not in substantial compliance. Is that correct? Because because that's all conjecture right now. HCD sends letters, they ask for more information. We looked at it and the town council felt that, that it could be argued that it was in substantial compliance. So it's a question, but the burden of proof, if it did come to litigation, would it be on the developer?
In the case where you turned down a project, where you actually disapproved a project, the burden of proof is on the city and the town.
Okay, so to prove
but
that
if YIMBY sues you, the burden of proof is on YIMBY. But if you turn down a project, because almost always the burden of proof is on the challenger to the town's actions, but the Housing Accountability Act reverses that. And so if you turn down a project, the burden of proof, for the builder's remedy or for any other reason, the burden of proof switches to the city.
But that's only if we are looking to deny the project?
Yes.
Okay, thanks.
Councilmember Rennie.
Well, related to that, hours ago, I heard you say related to Clovis that, and I thought it was related to Builder's Remedy. HCD had wrote them a letter that they weren't in compliance, but the courts disagreed. Did I hear that correctly? Yeah. And is it Builder's Remedy, and was it a letter that the courts then said was not correct?
No, I'm sorry, I didn't explain it properly. The Clovis case did not relate to Builder's Remedy at all. Clovis was basically sued by Mrs. Martinez and basically the Public Interest Law Project. So it was a straight-on attack on their housing element and on the zoning not properly implementing the housing element.
And I thought you said that the court said HCD was wrong, so how?
So HCD had found Clovis to be in compliance with state law.
Oh, okay.
And in that case, the housing element's entitled to a, quote, rebuttable presumption that it actually is in compliance with state law. And so there's a higher, in a lot of ways, a higher burden of proof on the plaintiffs. The court felt that the language regarding the minimum density of 20 units an acre was not ambiguous at all, and that HCD was clearly wrong, and so had found, and so basically found the housing element not in compliance with state law, despite HCD's finding it in compliance. Poor Clovis. Contrary to that, in an older case, the Fonseca v. Gilroy case, I told you, HCD had found the housing element not to be in compliance with state law, but in that case, the court disagreed also with HCD. So it is correct that the courts make the last call about whether a housing element's in compliance with state law.
And at least twice they've disagreed. Okay, thank you.
Okay. Yes, Chair Barnett.
Can you describe the application of these housing laws to senior care facilities, either rental or purchase?
Like an assisted living facility?
That's the current term, not complex.
They pretty would clearly apply to independent living facilities, but it's much more complicated with assisted living facilities. There is a Superior Court case that says they are housing developments. The difficulty comes in applying something like an inclusionary ordinance to an assisted living facility because they're licensed by the state, and the state is supposed to regulate the rents and so forth and so on. And so there's both practical and legal difficulties with applying inclusionary ordinances to assisted living projects. And then there's also problems with density bonuses, kind of depending on whether the units are, often assisted living units are actually dwelling units. My father, for some time, was in an assisted living facility, and he had a bath and he had a small kitchen. So I think that would have been a dwelling unit. So it does often become more complicated in applying these laws to a project with assisted living or, some other type of licensed facility. And I think it becomes very much a kind of a case-by-case issue, depending on exactly what's proposed.
Councilmember Hudes.
Just as a follow-up to that, is this an area where the law and the practice has changed? Because I believe at one point we were told that we could not count any of those units toward our RENA, and it appears maybe that's changed, is it?
It really depends on whether the units are dwelling units or not. So do they qualify as a dwelling unit? The small unit my father lived in, I think, would qualify as a dwelling unit. So that the issue is whether they're dwelling units or group quarters, which would be more of a dormitory situation. So anyway, a lot depends on exactly what the facility is.
And many of these are continuing care, so there's a range of
Right.
type of dwellings within a development.
Right, and so often the portion that's more of a nursing home cannot really be counted as a dwelling unit. Yeah.
Okay, thank you. That may be something we might want to follow up on with regard to our achieving our RENA allocation with our current cycle.
Okay, Commissioner Burnett.
Yes, thank you. To follow up on the original question I asked about protection for the smaller towns and like Los Gatos, because we're in such a high fire area, and you mentioned we would have to address our legislature or legislators. So would you recommend that we would maybe have a meeting with them so that whoever, that would be most relevant to our need to have some kind of ordinance or amendment to these laws to protect the smaller towns that have the high fire dangers, and that it could maybe have an impact on some of these laws that towns that do have such a serious situation, potentially serious, that we could have some kind of exemption or some kind of protection. I mean, I'm not a lobbyist or somebody, but I think it's always worthwhile for a community to meet with its legislators. Thank you. Yeah.
All right. Any other comments? All right. With that, first of all, I want to extend a huge thanks to Barbara Kautz for all of the time, expertise, and for being willing to be here and give us so much of your time, where clearly we brought you in to talk about specific state housing laws and obviously ventured into a variety of other areas. But we have a curious group, and you're a great resource.
Well, thank you very much. I enjoyed it.
Thank you. And I also want to thank our staff for, putting this together, for collaborating on the questions, getting everything done. I want to thank the planning commissioners for joining the town council, along with my fellow council members. And I especially want to thank our public for, weighing in, for bringing up so many issues. And it's always important to hear what you're thinking. And we are always open and available. So I think we've all learned a lot, and there's more to be done. And with that, I will adjourn the meeting.